Please turn off all cell phones and put them away.
Rise, Justice of the Appellate Division, Supreme Court, First Department. You all persons having business with the Appellate Division, are here, be attended and shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division, First Department. I'm about to call the calendar, and we have a pretty full house today. And what that means for you and for us is that we're going to have a very busy calendar. We have a lot of cases with a lot of multiple parties. I'm going to ask you to please be considerate of the bench and as well as your colleagues at the bar, and request only the time that you need for oral argument. And also, I would urge you to understand that if I give you less time than you request, which is likely, that it is not a reflection on the consideration that we're giving your case. We have your briefs, we have the records on appeal, and we're fully familiar with your case. So please only argue the issues that are most important to you. One final word, and that is the rule here at the Appellate Division regarding masks. While you are arguing a case and you are actually addressing the court, you may remove your mask so we can hear you, and we will likewise do the same. When we are talking, we will each remove our masks. Otherwise, I am going to request and insist that you wear a mask. With that, we'll begin the calendar. The first case, People versus Baez. Submit. 215 West 84th Street versus Osu.
5 minutes and 3:45.
5 minutes for responding.
We're going to do 5, 2, and 5. Thank you, counsel. TJ Children, submit. Lopez v. 1675 Realty.
Appellate, 5 and 2, please. 1 request
5, 2, and 5. Thank you, counsel. Behar against Sanioff.
We're ready. 5 and 2.
5, 2, and 5. Thank you. Arnson versus City of New York. 7, 2, and 7. Thank you. People versus Wilhelm. Submit. People versus Harry Artis. Submit. Mcdaniel versus City of New York. We have uh, let me finish. We have two cases. We're going to argue them together. This is one of those cases with multiple parties, and interestingly enough, everybody's an appellant. Okay, so let's start with the City of New York. What are you requesting? Okay, Liza?
5 and 2, Your Honor.
Triumph? 5 and 2, Your Honor. Plaintiff? 5 and 2, Your Honor. Okay, the City of New York, I'm going to give you 4 and 1. Liza, you likewise will have 4 and 1. Triumph, 4 and 1. And the plaintiff, you have 6 and 1. Thank you. People versus Veras. Submit. Skeet versus New York City Transit Authority.
Appellate, request 5 and 2, please. Responded right now, request 5 minutes, Your Honor.
You don't have a cross appeal, do you?
No, I don't, Your Honor.
Okay, so 5, 2, and 5. Thank you. Dafa Wiest against Friedland Properties. Excuse, wait, what party are you representing? And you're requesting, I'm sorry? 7 and 5. Okay. Friedland?
Robert Friedland requests 5 and 1, please.
Scalpel? United Drilling.
5 and 1, Your Honor.
All right, Defa West, I'm going to give you 6 and 3. Friedland, 4 and 1. Scalpel, 4 and 1. And United Drilling, 4 and 1. Thank you. People versus William Fletcher. To submit. People versus Shawnee Jones. Okay, 4, 1, and 4. Thank you. APR Energy Holdings versus Deloitte Tax.
Good morning, Your Honor. Appellate, request 8 and 2. Your Honors, there are 2 respondents.
Yes.
Heard with each request 5.
All right, the appellant, I'm going to give you 6 and 2. And the respondents, I'll give you, you have some overlapping arguments. I'll give you 4 for Deloitte Tax and 3 for Deloitte Spain. People versus Gustavo Rodriguez. I'm going to give you 6 and 2 and 5. Thank you. Curion versus Schreiber.
Good afternoon, Your Honor. Appellate, request 5 and 2.
5, 2, and 5. Thank you. People versus Sanchez. Submit. Cohn versus Cohn is a submit. And Mushlam versus Nazar is a submit. Okay. The first case on the calendar is 215 West 84th Street versus Azu. Step up, please. Okay. Appellant, you can take the podium.
Thank you, Your Honor.
Okay. You can proceed.
Thank you, Your Honors. May it please the Court. The Court should reverse the lower court's decision to stay this action for two reasons. First, the Court lacked authority to stay the action because neither party requested a stay, and such relief was drastically unlike the relief requested by the parties in the underlying motion, which was partial summary judgment. The second reason is because in order to issue a stay, there must be a complete identity of parties, claims, and relief sought in the two.
I'm not sure. I know you say that, and that's your argument. I'm not sure where that comes from. Why does there have to be a complete identity, and where in the law does it say that it's got to be a complete identity? I will allow you that if there is, that's a pretty strong case for staying one or the other. But here there are some very significant overlapping issues, are there not?
No, there are not, Your Honor. What the case law says, and it's cited in the brief, is that the relief that's granted in one has to resolve the issues in the other. What we have here in the main, in the Supreme Court action, is a case.
Well, let me step back a little bit. You started the holdover action, did you not?
That's correct.
Right. And you were seeking possession.
Seeking only possession.
You didn't ask for rent and or use and occupancy.
Not rent, only use and occupancy, not rent. Because in the Supreme Court action, we sued for the rent, the use and occupancy, but the main causes of action were the prima facie tort cause of action and the breach of good faith and fair dealing and a breach of contract cause of action. Those have nothing to do with possession. They're for monetary relief only. The resolution of the holdover proceeding, which is in the main has to do with possession, will have no effect and will not grant either party relief in the Supreme Court action.
If you're denied possession, doesn't that affect the Supreme Court action?
It does not, Your Honor. If, for example, there is a technicality on a service issue in the holdover proceeding, something of that nature, that would have no effect on the claims in the Supreme Court action. And what the court should keep in mind is there is no dispute here of the nature of the occupancy. In fact, in the pleadings in the Supreme Court action, the respondent has admitted that the lease has expired, has admitted that he was a holdover month-to-month tenant, and that the tenancy was terminated, and that he remained in possession. So the resolution of the holdover, there is no resolution of the holdover that can create a tenancy. It can't happen. So whatever the resolution of the holdover is, whether it be that my client, the landlord, gets back possession, or it's dismissed because of some jurisdictional defense, and we don't know what those defenses are because the holdover proceeding is currently stayed indefinitely because of the ERAP law. So what my client is now looking at, which is highly prejudicial, is not being able to proceed with either the holdover proceeding or the Supreme Court action, even though it's seeking entirely different relief. In the Supreme Court action, my client is seeking to recover, the complaint requests $25 million in damages because the respondent is holding up.
Counsel, let me ask you this, right? Your first cause of action is for a breach of relief for the failure to vacate. And
That's correct.
If in the holdover proceeding, the court finds that you didn't serve, and therefore there is no cause of action or no finding of breach of the lease.
That wouldn't be what in the scenario that Your Honor
Right.
proposed, that would not be the finding.
Well, you have to, in order to find a breach of the lease, right, you have to find that you follow the procedural premises for for relief,
But it
which
wouldn't-
you might not.
But it wouldn't be a breach of the lease. It's not a breach of the lease claim. It's for holding over.
Your claim is that I am being subject to damages, tort damages, because you won't vacate the apartment, right?
In the Supreme
And
Court action.
if there is a finding in the holdover proceeding that you weren't entitled to vacate or possession, that would affect your claim in the Supreme Court for $1 bazillion in damages because you didn't leave the apartment. I'm sure that that is true. So, and with respect to prejudice, right, you've been offered UNO, correct?
Incorrect, Your Honor.
No UNO at all?
No UNO at all. We were offered, what the respondent cleverly did was attempted to pay the back rent.
Okay.
Plus a month, which, as Your Honor probably is aware, could create the argument.
And you could say, I will accept that without prejudice to everything, which would then ameliorate your prejudice.
That's what we tried to do, Your Honor, and they would not agree to that.
Okay, let's hear from your adversary. You'll have time on rebuttal. Thank you.
Afternoon, Your Honors. Jeffrey Metz for the respondent. First of all, Your Honors, this appeal should be dismissed. This appeal is from an order which denies re-argument. Actually, it's the second order that denies re-argument. If you take a look at page 174 of the record, you'll see the initial order to show cause that was denied by Justice Krauss. The very next day, really the very next day, they brought on this motion seeking the same relief. Instead of saying it was under 2221D, they left that out, but they used the exact same arguments that they had before. As a matter of fact,
But then she denied that. She denied that second motion, and isn't that appealable?
No, because it is it's not what you style it, Judge. It's what it is. And if you take a look, they're saying this is to vacate or to modify the May 6th order, which is not before this court. But if you look at the affirmation that is submitted by my adversary, even goes so far to say that it's submitted in support of re-argument. There are 4 or 5 discrete instances in his affirmation where he said the court was incorrect this, the court was incorrect that, said it 4 or 5 times. It's the same thing that was said in the denied order to show cause.
So what should the appellant have done in order to get this issue before this court?
Well, I really don't want
if
to
you
tell
say
him
this-
how to
this-
practice,
if
but
this was-
I have
No, if
solutions.
this wasn't the way, what's the alternative that should have been followed?
Well, first of all, Judge, if you take a look on NICEF, they filed a notice of appeal from the May 6th order. They've never perfected it. Instead, they charted this procedural course. Now, here's the second thing. When the order to show cause was when they make this claim that they needed some kind of appealable order. Well, if that's the case, and I don't believe that it is, they could have made a motion under 5513 for permission to appeal. They didn't do that. Instead, they sought re-argument. The third thing is, when the order to show cause was denied, they could have come to this court under 5704A. They didn't do that either. Instead, they recycled the arguments that they had down below, and it was denied the second go-around. Now,
I want you to, right, because I think we understand your procedural argument, but I want you to spend some time arguing the merits of whether the appeal would succeed, assuming we had jurisdiction.
okay, well, look.
Or wouldn't.
Judge Krauss found a couple of things. One, that there were overlapping issues. There's no question that there are. Paragraph 20 of the petition seeks use and occupancy, as you pointed out, Judge Scarpula. Second cause of action in the complaint seeks use and occupancy. Now, they trumped up this claim because, look, my client filed for ERAP. There's a stay, so they brought this case essentially to bully him out, seeking over $75 million in damages. The holdover proceeding asked for legal fees. The third cause of action asked for legal fees. And as you pointed out, everything revolves around possession. Every claim that he has depends on whether whether my client has withheld possession improperly.
Counsel, where is the ERAP claim now? What's happened with it?
Well, it's interesting that you say that, Judge. My client's been conditionally approved for ERAP. The landlord has a choice to fill out paperwork to take care of that and to vacate the stay. I think he has taken the position that he is not going to do that. But that's where we're at as far as that
But,
goes.
and let me ask you this, does your client concede that he had a month-to-month tenancy, that the tenancy was over?
No, there's no, look, he's a month-to-month tenant. We never denied that, Judge.
So
but-
even if he gets the money, he's out, correct?
No, he's not out, Judge, because we haven't put in any defenses to the holdover proceeding. We believe that we have very, very serious claims for retaliatory eviction. And if I succeed on that, under 223B1, I get another year. So it's not written in stone that he gets possession back. So I would suggest to you, Your Honors, that this is an exercise of discretion under 2201. It's very broad, and you need to show an error of law to vacate that. So I would ask, for all the reasons that I've stated, that the order be affirmed or
Well, what about your friend's argument that the court was without jurisdiction or without the power to grant this quote-unquote sua sponte because that really hadn't been asked?
Well, it is true that she granted it sua sponte, but she cited to a case, which we cite in our brief, that gives the court the ability to do that. The statute certainly gives you the ability to grant a stay in a case on terms that are just, and here they are, because, remember something, Your Honor, they went, they talked about use and occupancy and rent and all that, but they sue my client under the first cause of action for over $25 million in damages, and then they say, oh, by the way, we also want the rent. So what do? We find a way, we scrape up the money, we tender it to them. They rejected that because they said, oh, you have a use and occupancy, 1 month of use and occupancy. Okay, fine. We send them another tender without the use and occupancy, exactly for the rent that they were claiming on their partial summary judgment motion, and they rejected that as well. So I will tell you, Your Honor.
So, but counsel says he rejected it because you refused to accept without prejudice.
No, Judge, it's a rental claim. It's a rental claim. We're trying to resolve.
No, but we all know
there's-
that
well,
there's
and
law
also-
that says
also-
that if you accept rent, you may be held to reinstate the tenancy.
He sued,
So it
but-
does make sense for that
No, so,
party to
but-
say,
well-
I'm not going to give up that claim.
Your Honor, the motion, the partial summary judgment motion, is for $10,000 of rent. That's what they sought. That's what they sought, and we said, okay, fine, we'll give it to you. Now they're going to say we don't want it after they brought the motion? It doesn't make any sense. They have made they have charted their own procedural course, Your Honor, and I'm telling you, this appeal should not be entertained, and if you do choose to entertain it, you should affirm it, because this is a proper exercise of discretion. Thank you, Your Honor.
Thank you. Rebuttal?
Thank you. Your Honor, I want to address the question that you first asked about the legal principle about the one action determining all claims and outcomes in the other. The quote comes from this court's decision in Somoza v. Pechnik, and it says, quote, a stay of one action pending the outcome of another is appropriate only where the decision in one will determine all the questions in the other, and where the judgment in one trial will dispose of the controversy in both actions. This requires a complete identity of parties, cause of action, and the judgment sought. That's the controlling law. And if that's the controlling law, then the stay here must be inappropriate and could not have been granted.
Okay, I understand your point on that, and we'll look into it, but I just want to clarify something. Did you make a motion for summary judgment in the Supreme Court action that sought rent?
Your Honor, that is how the stay was issued. We made a motion.
So is that a yes?
Right, we made a motion for partial summary judgment on the claim for rent.
On the claim for rent. So
Correct.
how could you get rent? How could you ask for rent in this action with a holdover proceeding that stayed? I don't understand it, and I don't understand further, if they give you the rent, how could you not take it?
Sure, I'll explain. Your Honor, in the holdover proceeding, we didn't sue for the rent. This wasn't a non-payment case.
I know it's not. I'm familiar with the difference between holdovers and non-payments. But in a holdover, you said that there were 2 months of rent that was outstanding, did you not?
No, we did not seek
You
or
didn't seek any money damages.
use and occupancy prospective, not the rent before the lease was, before the month-to-month was
I'm going to
terminated.
take a look at the record, thank you.
I want
All
to
right.
answer your second question.
I'll give you half a minute to do so.
You asked about why we didn't accept
Yes,
the rent. I
correct.
want to answer that, Your Honor.
Correct.
If we had accepted the rent without a court order to do so, you can bet that respondent's next move would have been to argue that we vitiated the termination notice and that his client still has a valid tenancy. That's the reason we didn't accept it. Thank you,
Okay,
Your Honor.
thank you. All right, the next case on the calendar is Lopez against 1675 Realty. Okay, you can proceed.
Thank you. May it please the court, David Metzger for the appellants. This is a straightforward negligence case. I know the court is familiar with the facts. I'd like to focus on just several of the issues. The first being that the judge below granted the motion for summary judgment of the plaintiff, even though there's a very significant question of fact, and that's as to the location of this particular accident. Because the city was a defendant initially, there was a statutory hearing, and that was in June of 2017. At that time, the plaintiff testified that he tripped on a raised crack. He didn't know where on the sidewalk it was. He didn't know if it was closer to the building, closer to the street, in the middle of the street. He couldn't reference particular landmarks. He couldn't state if it was closer to the street ahead, Walton Avenue, or the street behind. The only landmark he could reference was a beauty salon that was a little bit ahead. He testified that there were no photographs taken by anybody and that he had not returned to the location. Apparently, he was unaware that the plaintiff's attorney had sent an expert 3 months earlier on March 8th, 2017, the expert, Mr. Marletta, who had already been to the site and took photographs of a very specific and zeroed-in spot of the sidewalk. And if you look at all the photographs, and there are many, that are attached to the record on appeal, you'll see that not every part of this sidewalk, there may be defects, but not all of them are an actionable defect. He went straight to a spot that was 13 feet, 19 inches from the curb. And again, the photos show multiple issues, we grant that, but not all actionable defects. There's no explanation below or in the respondent's brief as to how that was accomplished. And it seems clear that, or not clear, but certainly a question of fact as to whether or not the plaintiff identifying that particular location of sidewalks subsequently at his deposition and also his girlfriend identifying it was because they were now pointed in that direction based on that chosen spot by the expert. In response to this, the respondent discusses a stipulation that my office had executed, but the stipulation just indicated that the particular spot that the expert subsequently identified, our client was aware of and did not remedy, but that's not the same thing as acknowledging that it's the location of the accident or that it was an actual defect. And again, the testimony that was given by the plaintiff at the deposition and by the girlfriend is really of no moment because, again, by that time, they had been pointed to the potential location of the accident. The other factor that there are multiple ones, but just given my time, that I want to focus on is whether or not this is an expansion joint.
Counsel, did you put in an expert affidavit?
No, we don't.
So what is it now, when you say, well, it's a trivial defect, based on what?
I didn't say it was necessarily a trivial defect. My point is that that defect, there's a question of fact as to whether or not that was the location of the accident. Whether or not there's an expert.
I mean, the plaintiff testified, and I printed out the picture, that he fell on this big giant crack. What's at issue?
The plaintiff testified,
Did he testify on the smaller edge of the crack or the larger edge of the crack?
two things, multiple things, but the plaintiff testified at the statutory hearing that he didn't know where on the sidewalk he fell.
Well, it's a pretty big, it's a huge crack,
But
right?
it's respectfully, it's not. If you look at that whole length of the sidewalk, not all of it is an actionable defect. There are multiple
How do
places.
you know that? Did you put in an expert to say that? You're not a, you have nothing to say.
It can be-
You can't say that without some proof.
Well, how can
Did
we?
you put in an expert
No,
that said
we-
some of that isn't actionable?
We did not put in,
Where is that statement coming from?
just from looking at the sidewalk, and even if,
That's your claim, that just you, the lawyer, looking at the sidewalk is sufficient evidence to raise an issue of fact?
well, we don't know, it's a large sidewalk. We don't know where the accident occurred.
Well,
There's
the
places on the
plaintiff
sidewalk
testified-
that don't have an actionable defect at all.
How do you, again, where is it that you have evidence of that?
It's before Your Honor, with the photographs that show the full length of the sidewalk and many portions of the sidewalk without an actionable defect. My claim, my argument here is not that it is, that particular spot is not potentially a tripping hazard, is that there's a question of fact if that was the particular spot where he fell. Just because there is an actionable defect in that particular location doesn't change the fact. May I just address one other issue?
You can address it on rebuttal. Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. Judge Scarpullo, to point out what you were talking about, there's nothing here. What you have is an incredible stipulation. Quite frankly, I think the defendant's strategy was brilliant. 13 years, this defect with 7 photographs existed, with Mr. Suarez, the superintendent, saying, oh, it was there, but I don't consider it a defect because my personal standard is that it has to be 2 inches deep and has to be 5 inches out. I want you to look at a case called Williams against Hopper. It's 9AD3D. It's my case. I lost it here. I put in an expert affidavit where the expert said that a driver had to drive in a certain way that wasn't contained in any statutory mandate or any regulatory mandate. I got killed in the decision. I got killed worse in the argument. You have to have proof. This is a basic summary judgment case. We establish prima facie entitlement to judgment as a matter of law. There is no conflict in the testimony. At plaintiff's 50H hearing, there wasn't any photographs. When he was shown the photographs, he identified the photographs exactly. There's no claim that the accident happened somewhere else. The pleadings are consistent. Everything's consistent.
Sir, did he offer any testimony at the 50H hearing that did bear on the identity of the defect, or the area in the sidewalk where he fell?
Yes, what he said, look, remember, it was pitch dark. We have to go into that also, Judge Higgins. It was pitch dark. I'll get into that also. So it was a very, very dark area. He was there. Ms. Lewin was there. He said he fell on a crack. Couldn't identify it specifically because he's a plaintiff. He's not a lawyer, and he's not a judge, and he was in horrible pain. He couldn't even get up. His girlfriend confirmed that, and he said it was near the beauty salon. He said he couldn't testify exactly how big it was. He said it might be 2 to 3 inches, but it was on this street. It was pled on this street. And we know for a fact that under your decisional law, Cuevas against Baruti, Rahm against Eurostruct, Hill against the City of New York, Faulkner against Allied Maintenance, and Colt against Rittman, something's not inconsistent because you expand on it. If he was shown that photograph at the 50H, he absolutely would have identified it. There's no contrary evidence. So you have to have, I'm sorry.
No, I just want to move you to a different
Sure.
issue that you alluded to, which is the issue of the illumination in the area.
Sure.
And it's a twofold question. The first is there at least an issue of fact on the question of illumination? And if there is, does that bear on the affirmative defense of comparative negligence?
So, Judge Gish, I'm going to give you a direct answer because I know you like it. No and no. Here's why. Factually. Mr. Suarez What he did was, in the affidavit in opposition, as you know, he submitted an affidavit saying, I've got these photos, 3 photos, never exchanged in discovery, never identified, no chance to authenticate them. And he said, on these photos, I know that lights should have been or would have been on because I put one of them in. Here's the problem. He wasn't there on the date of the accident. So his testimony respecting what the condition was when the plaintiff fell with his girlfriend 4 feet behind him is pure speculation based on his testimony.
In that statement, he goes on to say that the light was functioning and illuminated on the night Mr. Lopez allegedly tripped and fell on the sidewalk adjacent to the building in February of 2017.
He did.
That speaks directly to the night of the whatever happened.
He wasn't, I'm sorry.
No, go ahead.
May I answer your question? I didn't mean to cut you off. He wasn't there that day. So, listen, I can say I'm Brian Isaac, I'm a judge of the Appellate Division. I can say it, it's not true. I have to have support to do it. He can't make that statement because he wasn't there. If he wanted to give...
Doesn't he also say that he checks every day? And perhaps he can't make a statement about that night specifically in the facts as you present them, but if they were working the night after or they were working the night before, wouldn't that create an issue that there was illumination? And wasn't there also a street light?
Well, no, according to RS, it was very, very dark. They could see something, obviously. The girlfriend...
I mean, in an urban setting, you don't usually have a situation where you can see absolutely nothing. I mean, you know, in the country, it might be so dark that you can't see. But in an urban setting, there are lights coming from apartments that are overlooking the area. And is the situation here, because as the picture of the building shows, this is a building of some size, and there are lots of windows overlooking the area of the fall.
But if I can, Judge Friedman, that's kind of a speculative statement based on an overreading of what he said. He could have made an argument, for example, that I was there the next day and I checked, I saw after... I'm sorry, may I finish?
You can finish your answer.
Yeah, that I saw the light was on the next day. He just didn't do that. And I would also point out that there is a doctrine of law out there confirmed in one of your decisions, Normandy against Lowenstein. It's not cited a lot, but there is a presumption that goes back to old Court of Appeals decisions in Delaney against Philhern Realty that one traversing a public way has a right to expect that it will be free from defects. And in Lowenstein, you specifically held that a plaintiff was entitled to a charge to that effect where the plaintiff fell into an open trapdoor.
Lowenstein's a jury verdict.
I'm sorry?
Lowenstein's a jury verdict.
100%. But the law is still the law. So my position is that we established prima facie entitlement to judgment as a matter of law, both on liability and on the affirmative defense, and that there was nothing in opposition that came back. And even if there was something on comparative under Rodriguez, we still went on the negligence cause of action. Thank you for listening to me.
All right, rebuttal.
Just a quick rebuttal and then to just address one other issue. The respondent focuses on the fact that there were no photos produced at the statutory hearing, where at that point the plaintiff could have identified the photo. I'm not familiar with the process of a defendant needing to go to a sidewalk and take a photograph of every potential defect or every portion of the sidewalk and say, is this it, is this it, is this it? That was on them, and they intentionally did not have a photograph at the statutory hearing.
Sir, marshal for me, if you would, all of the facts that support finding of a triable issue of fact with respect to comparative fault.
There's the evidence about the adequate lighting from the super, which has already been discussed. The plaintiff testified he was not looking down. You can cite to the record 576. The girlfriend says she was able to clearly see his foot come into contact. We just heard that it was pitch black, but clearly it wasn't pitch black.
Doesn't that creates if he says I couldn't see a thing and she says, oh, I saw him fall into it, that creates an issue of fact as to whether he saw what could be seen, correct?
Correct. Yes, and he could appreciate that there was no garbage, that there was no debris in the area. And again, everything that was put in the affidavit by the superintendent, and that was a line of questioning that was not explored at the time of the deposition. So there was nothing untold about attaching that affidavit, and the photographs that they're referencing are Google photographs. And the case that I cited makes it clear that as long as you can identify that as being, as it was at the time of the particular accident, that those are admissible. So those multiple things create the issue of fact for the affirmative defenses. And the one thing that I just would like to add is, and it's not a matter of semantics, it's actually a very relevant point, is that this was an expansion joint. By the plaintiff's expert's own admission, this was an expansion joint. And all the cites by the court and by the plaintiff dealt with sidewalk flags. And I just want to point out one other.
You don't escape liability because it's a joint between the flags. I mean, if there's a defect.
But the court has made clear in Marks and in Fayol, forgive me if I'm mispronouncing it, that that has to be actually pled, and that the Department of Transportation statutes affecting expansion joints need to be pled. That if you cite the law regarding sidewalk flags, that is not sufficient. And if you look at the order and you look at the motion or plaintiff's motion, the reply, and all the respondents' papers, there's nothing about the Department of Transportation laws. And I just would like to focus on one portion. The New York City Administrative Code, Section 19-152A7, 152A is cited by the court. A7 states that this is ways in which there can be liability imposed. A defect involving structural integrity, which means a flag with a common joint.
I was going to say, if you give us a section, we can read it.
Yeah, it says that a common joint.
I don't mean to be really strict about this, but we can read it. We have a section.
Just
I jotted it down, and I will read it word for
one
word.
sentence, if I may, please. Just that one section, Section 7, draws a distinction between an expansion joint. So that's why I'm referencing that. The court and the legislator does have an exception for expansion joints. Thank you.
We'll read it. Thank you. Thank you both. Behar against Sanioff. Take the podium. And you could take your mask off so we can hear you if you would like. You don't
Good
have
afternoon,
to
Your
if you don't want
Honors.
to. You can proceed.
The issue before the court on this appeal is probably the most simple and basic you'll hear all day. It's whether the filing of an amended complaint requires the counterclaims contained in the original superseded answer to be repleted in an amended answer to the amended complaint. The answer is yes under CPLR 3025D. Following the plaintiff's filing of an amended complaint, the defendants made a pre-answer motion to dismiss, a pre-answer motion to partially dismiss, which was granted in its entirety. Following that motion, they moved for contempt. At no time did they move to file a late answer, or it wouldn't have even been late, it would have been on time. They didn't file an answer at any time from the time the amended complaint was filed until the complaint was dismissed, until the action was dismissed. They are now raising the counterclaim. Also,
So is your point in that if they didn't answer the amended complaint and reassert the counterclaims, that when the court severed and continued counterclaims, there were no counterclaims to continue?
yes, Your Honor.
Is that your point?
Yes. Once the amended complaint was filed, the original answer was superseded. It became a legal nullity. It's not in the trial record. It's nothing. So that is our position, that the counterclaims did not exist at the time that they were severed, and that they cannot now be resurrected because there's no complaint to answer.
They could be separately brought.
That's correct.
Right. Has the statute of limitations passed?
The statute of limitations, yes. However, it might be able to be saved under the relation back doctrine.
Okay. Okay, thank you.
Your Honors, may it please the Court, Joseph Buckley on behalf of respondents. In answer to the threshold question, there was no amended complaint ever filed without a counterclaim because the amended complaint didn't need to be responded to. There are three counterclaim plaintiffs currently at bar: Abraham Sanyoff, Charlotte Sanyoff, and 25 Grove Street. In December of 2020, both Abraham Sanyoff and 25 Grove Street succeeded in their 3211 motion to dismiss all of the claims against them in the amended complaint. Therefore, they were not required to answer. Only the respondent, Charlotte Sanyoff, was required to answer, but at that point, in the remaining 3 months of the case, we have a very unusual procedural history here. She filed instead, joined by 25 Grove Street and joined by Abraham Sanyoff as counterclaim plaintiffs. They filed a motion to dismiss the complaint with prejudice because of the contempt of court of the appellant.
Which complaint did they move to dismiss?
I'm sorry?
Which one? Which complaint?
The amended complaint, in lieu of an answer. First they moved under 3211 and got most of the complaint and most of the parties dismissed, including two of the appellants today, 25 Grove and Abraham Sanyoff. So they never had the obligation to file a response to the amended complaint, and they had already joined issue on the counterclaim. They'd filed a valid counterclaim, and issue was joined on the counterclaim a month late by the plaintiff or appellant, but their issue was joined, so there was a valid counterclaim. And
Isn't there a healthy body of case law, though, that says once an amended complaint is filed, that becomes the operative pleading?
Yes, but it doesn't, there's no case law that's been cited or that we're aware of that it vitiates a counterclaim where issue has been joined unless there's an actual amended complaint filed that abandons a counterclaim. They cite one case where a counterclaim, the second time it was filed, didn't have where an answer the second time it was filed to an amended complaint didn't include the counterclaim. Here, we hadn't reached the stage yet to file
Did the amended complaint, though, assert claims against all of the defendants?
The initial complaint asserted...
Well, the initial complaint, we know it did. You said it did.
And the amended complaint also asserted claims against all of the defendants. And we moved in response under 3211, and most of those claims were dismissed.
I understand, right.
And therefore, no answer was warranted. So there was no...
Well, wasn't there an answer warranted to what remained of the amended complaint?
Only on behalf of one of the three parties before the court today. Two of the three, Abraham and 25 Grove Street, had no obligation to answer, and they were entitled to rest on their previously filed counterclaim. And as I said, with respect to Charlotte Sanyoff, the third counterclaim plaintiff, she promptly moved to dismiss and won because Justice Perry, who had case managed this case very actively, knew full well that the counterclaim was actively being pursued. And he had previously ordered, if the plaintiff appellant does one more contempt of court, I'm throwing out her claim. So Charlotte and the other parties moved.
So you're saying that you can have the original answer and the answer to the amended complaint are both together operative pleadings?
There was no answer to the amended complaint. None was required. There was only an answer to the initial complaint. We moved under...
Somebody had to move to answer the amended complaint, correct? Somebody had to answer the amended complaint. So you're saying
No.
there should be...
It was ultimately dismissed by the court. No answer was required.
Well, the answer would have been required after the first, excuse me, I don't know how many in this sequence, when there was a motion made to dismiss under 3211 the amended complaint, and you got partial relief. The obligation to answer what remained of the complaint existed or ran from that period of time. That I'm sure of. The motion for contempt to dismiss, which is not a 3211 basis, doesn't relieve you of the obligation to otherwise answer the pleading that is in existence, which would have been the completing as called down by the court in the 3211 motion to the amended complaint.
But as to Abraham Sanyoff and
I
25 Grove, there was no...
That's a different issue.
If we're focusing just
But I'm
on
not-
Charlotte.
But as to Charlotte, she would have had to answer that complaint. She couldn't just ignore it.
But she had no intention to, and they never claimed her as defaulting. They never cross-moved, as they should have, to alert Judge Perry that, oh, they have we believe there's a default here, so these aren't proper movements to dismiss the case. They didn't do that. When Justice Perry severed the case, he had no indication of their position.
I think that's neither here nor there. The question is who had an obligation whether you had an obligation to reassert the counterclaims when a new pleading was asserted.
But as to
That's really it.
As to Abraham Sanyoff and 25 Grove Street, they had no such obligation. They won their 3211 motion, and they were entitled to rest on their, and issue had been joined. I mean, we cite First Amendment.
Can I ask you another question? I'm going
Yes,
to
Your
ask
Honor.
you what I asked your adversary. Has the statute of limitations passed?
Yes, Your Honor.
It has.
It's a serious matter.
When did the statute of limitations pass?
Well,
Why don't you just file new counterclaims to preserve your record?
We weren't even alerted to this. Neither Justice Perry nor our side were given any notice. They should have cross-moved on this to make the point to Justice Perry, and they didn't. They waited till after the case was severed, and they said, oh, there's an error here. Justice Perry committed no error. He had no notice whatsoever that this was their position. They should have cross-moved in January of 2021 if it was their position that somehow Charlotte Sanyoff was in default in not answering, which we don't believe she was, and they didn't take that position. And they didn't, the only standing that Abraham and 25 Grove had to file the motion to dismiss was as counterclaim plaintiffs, because they were already dismissed as plaintiffs. And yet, the plaintiff made no cross motion to draw the court's attention to that. They waited until after the severance. There was literally no error in this case, Your Honor.
Okay. All right, let's hear rebuttal from your adversary.
So why did Abraham Sanyoff have to do anything?
I'm sorry, could you repeat that?
As to Abraham Sanyoff, since they were out under 3211, why would they have to do anything?
They had to file a plenary action. They couldn't just sit on a...
Had they put in counterclaims?
Had they put in counterclaims to the original complaint that, in the original answer...
It's dismissed under 3211.
Yes.
So why do they have to do anything at that point? Why are they not able to rely on the counterclaims that they already put in?
The counterclaims that they already put in have been superseded by an amended complaint. Issue is not joined. That doesn't even matter. Whether or not issue is joined on a superseded complaint doesn't matter. It's still superseded.
It only superseded as to Charlotte, right? No?
No, the same defendants were included in the amended
How could
complaint.
it be superseded if the case was dismissed as to them?
They were required to file a plenary action, a new action to preserve their claims.
I just want to make sure.
The counterclaims are dismissed as a matter of law when they win the 3211 motion?
No, I'm saying that the counterclaims were vitiated by the filing of an amended complaint. The pleading that contained the counterclaims was vitiated. It's not a part of the record. The original answer to the original complaint.
The complaint was vitiated because they won their 3211 motion.
Yes, but then we filed an amended complaint we stipulated to permit the plaintiff to file an amended complaint And upon the filing of an amended complaint, they did not attempt to file an answer or reassert their claims in a plenary action.
Did the stipulation permit you to amend the complaint as to Abraham and 25 Grove?
Yes. It didn't put any limitation on parties. Also, the plaintiff's reply to the original counterclaims was rejected as untimely. And there's no indication that I can find that indicates Judge Perry compelled their acceptance of a late answer. So,
You mean a late reply to the counterclaims?
yes, yes, a late reply to the counterclaims.
It's a procedural morass.
Also, it is not our responsibility to remind the defendants to preserve their rights.
Okay, thank you. Thank you both. Arnson versus City of New York. You can proceed.
May it please the court, my name is Jamison Davies for the appellant. This court should reverse Supreme Court's decision and dismiss the petition as unripe. Under the controlling law of the Court of Appeals and in this department, a petition challenging a negative declaration under SECRA is not ripe. Petitioners
Can I ask you a question? I mean, one of the arguments that you make about ripeness is that more stuff needs to be done, right?
Correct.
Okay, and one of the stuff that needed to be done was the amendment of the zoning resolution, correct?
That was one of the things that had to be
One of the
done. That was
things?
not done at the time the petition
It was
filed.
not done at the time, and that seems to be out of the Court of Appeals, the Eady decision, right? Where they talk about the zoning resolution needing to be adopted in order to trigger the 4-month statute of limitations.
They talk about the zoning resolution because that's what was at issue in that case, but more.
So with the zoning resolution, well, so I'll take that as a yes. So was the zoning resolution in this case ever amended?
The zoning resolution was amended, Your Honor. The amendments do not go into effect. There's a provision that says that the zoning amendments will not go into effect until the enabling legislation and the rules are finalized. So the zoning amendments have been passed by the council, but they don't go into effect until all the other steps are completed.
So the petitioners in this case, and you wouldn't argue that because the zoning resolution was passed and they didn't bring a new Article 78 within 4 months of that, that they're precluded from otherwise challenging the EIS?
Yes, because if they brought a timely action when all of the steps had been finalized, then we wouldn't challenge.
So you're making a representation that even as we stand here today, that the 4 months has not started to run.
Correct, because
And what would start to trigger that?
So the court in Eady makes 2 points in distinguishing stop the barge from save the pine bush. The court says that there is the enactment of additional legislation. Here we have the enactment of additional legislation that will have to happen. That's the implementing legislation that still has not been passed. And additional agency action. Here there's going to be additional notice and comment rulemaking under CAPA by one of the agencies that's charged with administering the new program. Once those decisions are finalized, that would also trigger the zoning resolution to go into effect. And at that point, the decision would be a final agency action subject to challenge. And I think it's important to note that those 2 bases on which Eady relies in distinguishing stop the barge, both are present here. Either one would be sufficient, but both are present here. And there's really no dispute that both are present here. There's no effort by the petitioners to distinguish the circumstances in Eady from the circumstances here.
Is there any way that the petitioners could get relief from the temporary condition that's existing?
Yeah, petitioners have actually filed a separate lawsuit that's currently pending in Supreme Court challenging the temporary program as of now. So
And you're probably defending it on the grounds that they're too late.
I'm not sure if we've put in our papers yet. We are defending it certainly on the grounds that it's too late might be one of those bases. Obviously, the court hasn't ruled on that yet. But the temporary program started in June of 2020. So, there is a valid argument that the challenge of the temporary program may be too late. But that the key point is that the programs are entirely distinct. And the thing that really drives this home is that Supreme Court granted them the relief they wanted, and the harms they alleged were not remedied. They still had to bring a separate lawsuit to attempt to remedy those alleged harms. So that shows that really the harm they were alleging is not remedied by the relief they're seeking, which is the annulment of the EAS. And that proves that here that the petition is not right. Petitioner's real only effort to distinguish EDs to rely on language that the secret process itself can in some cases inflict an injury, but that is, the court there was talking more about where an EAS requires some mitigation measure that would limit a property owner's right if they were not allowed to cut down trees or something like that. That would inflict a concrete injury. Here, there's no concrete injury that's inflicted on any petitioner by the issuance of the EAS until the final rulemaking and the final implementing legislation happens and the zoning amendments go into effect. Even if the court were inclined to reach the merits, the decision should still be reversed. DOT's environmental review did exactly what SECRA requires. It took a hard look at the potential for environmental impacts and found that no substantial impacts within the meaning of SECRA were likely. Petitioners don't even dispute that DOT followed the guidelines set out in the SECRA technical manual, which this court has held on several occasions is presumptive evidence that SECRA was complied with. Nor do they cite or distinguish any of the litany of cases that we rely on to that effect. Instead, they rely solely on the conclusions of their own expert, who has, of course, a differing view of the likely impacts, but the responsibility for evaluating the relevant evidence and coming to a conclusion lies with the agency, not with the petitioners or the courts. Unless there are any further questions, we would urge this court to reverse and dismiss the petition.
Thank you, counsel.
Good afternoon. Michael Sussman representing the petitioner respondents. In this particular case, Your Honors, the City of New York has proceeded long apace from June of 2021 when they claim to have cleared the environmental review here, environmental process. They say that they've fully studied the effects of the permanent open restaurants program when, as you've just heard, the open restaurants program that they studied was in some inchoate form. It's not even a program that could be studied. We went to court because under Stengel, the Second Department decision, it's very clear that if 4 months had passed and we did not go to court, we would eventually have been precluded applying Stengel, which the Court of Appeals had an opportunity to review and did not review. With regard to the Edie case, it seems to me the greatest distinction here is that in Edie, you were dealing with one agency which was going to take successive actions. Here, you were not dealing in that situation. You were dealing with the Department of Transportation and Planning, which had one discrete role in the process. Their role in the process was to finish an environmental review. They did not, they finished the environmental review, even though I'll get to in a moment, that environmental review could not meet the laugh test. It was an absurd environmental review. The environmental review proceeded at a time, a year after a program just like the one they intended to make permanent, the one that they were supposedly reviewing, had started, and they did not do any empirical review as to what was in fact going on in the city. That's what the petition shows. With regard to noise, sanitation, congestion, quality of life, the very factors SECRA requires a review on, they ignored all of those factors. They literally ignored them. That's what the Judge Nervo, found. So here what you would have, they say there's no injury. Of course there's an injury. The injury is that every successive decision maker, and there are a number of successive decision makers, can say there's no negative impact. We don't have to consider any mitigation. We don't have to do anything to actually straighten up this program because we found no environmental mess. And as you've heard, that's important here particularly because they didn't even have a program they were studying that was finalized. So if in fact there had been, when he says we followed SECRA, SECRA is an inclusionary process, as this court knows. If you look at the Jackson case, my northern West Manhattan is not for sale case, what do you find? You have extensive environmental impact reviews, scoping sessions, public participation, up the kazoo. And this court has affirmed that is the secret process. Here they averted all of that. Why did they avert all of that? Because in September of 2020, the mayor said, we're doing a permanent program. And 7 months or 8 months later, they gave a negative declaration with no significant study and no public input.
So, counsel, how do you square your argument with your adversary's statement to the court straight up? When this is all done, the petitioners will be able to challenge the no negative impact finding.
It's an absurdity. That's how I swear it.
I don't,
Here's
what
why
do
it's
you
an
mean if
absurdity.
he said, if?
Let me explain why.
Yeah.
Briefly. The environmental review process is completed. Nothing they're now doing relates to the environmental review process. If you read through their brief and all their submissions by their affidavits, they're not saying they're doing additional environmental review. They're not saying they're complying with SEQR. They finished that process. Having finished that process to say, we're in this state of perpetual motion here. We don't really know what we're doing. We have a mayor kicking down the sheds after they, in fact, say, this is fine. It doesn't make any sense. That part of the process is done, and before we use it as a predicate for everything else, we should ensure that it's done properly. It was not done properly. If you
Your
look at
argument, if I listen to it, it's a policy argument, and I think it has some appeal that you would want to, when an EIS comes at the beginning, to review it at that time. But I guess the real question is, for you,
Sure.
how do you square that with the Court of Appeals decision? I know you're relying on appellate division authority, but I'm having a hard time, personally having a hard time squaring your argument, no matter how appealing it might be on a public policy point of view, with the Edie case.
Because Edie is not categorical. Edie is itself qualified. Edie had itself been preceded, Your Honor, by cases like Stop the Barge, which we cite, by Jones, which is another Second Department case, which say exactly the opposite. They say exactly what Stengel says.
But that doesn't help you.
It does help me because Edie does not have such a categorical rule.
It's the Court of Appeals ruling on it, and if it's contrary with prior appellate division decisions, that at least says to me how we construe precedent that those earlier decisions, even though they might be analytically appealing, are not the law of the state.
Well, what do you do with Stengel? Stengel says exactly the opposite.
Maybe Stengel is wrong.
But the Court of Appeals had an opportunity. If the party who lost Stengel went up to the Court of Appeals and said,
you know, having a lot of experience in the Court of Appeals, either accepting or rejecting leave, I really don't think you could read that much into that.
Well,
quite frank, I wouldn't personally.
Well, here's the problem that petitioners have, Judge.
Yeah.
We have litigated fully the issue below. And there is nothing about that litigation, the petitions, the affidavits, that we would submit anew when
It's not going to change. I understand.
Nothing's going to
your
change
argument.
because there's nothing about the environmental review process that's going to be any further advanced or different. They finished their environmental review process.
I get it.
It's a policy argument. It's not just a policy argument. It's an argument about the very predicate of everything else they're going to do.
But it's also an argument about doing something piecemeal, about doing it in stage 2, and then another lawsuit in stage 3, and then another lawsuit in stage 4. Counsel, you have a second lawsuit.
I know, but it's totally different. Wait, I understand that.
Let me suggest to you maybe that I finish what I have to say.
Okay, sure, sorry.
So, you already have a second lawsuit with respect to the temporary structures. And so you're going to sue on this, and then when the regulations come out, you're going to sue on that, and then when the zoning resolution goes into effect, the point is to do it all at one time, as opposed to piecemeal.
They're radically different lawsuits with radically different issues being raised. SEQR is biblical. SEQR is not about the substance of zoning text amendments, and we're going to challenge this and challenge that. SEQR is about an inclusionary public process which is intended to predicate something of this significance. SEQR was not followed here. Whatever counsel says, it was not followed. And he can't cite a case of anything of this magnitude in the city of New York, anything, where they tried to subvert SEQR, did not go through that public process, and proceeded apace. Let me just address briefly the second lawsuit because it's being obscured. And
I'm going to give you only a minute to do that.
I only need that.
Because you're out of
Thank you.
they
The
take
second
less. I'm gonna give you less.
The second lawsuit is about the fact that there is no emergency currently pending. In fact, I just got a call from the New York State Attorney General's office telling me that Governor Hochul has not extended the emergency, which is the supposed predicate for the temporary open restaurants program. That's what it's about. It's not about whether there should have been an environmental review for that program. There needn't have been. It was an emergency program.
Right.
The emergency's gone.
We understand. We
So
understand
they're
that
not
point.
related, and it's not about piecemeal litigation.
Okay. Rebuttal.
Your Honors, I'll be quick. I want to pick up on that last point because it shows exactly why this is not ripe. The court below held that the effects of the temporary program were the injury that allowed this petition to proceed. And as counsel just explained, the lawsuit about the temporary program is entirely different and distinct from the lawsuit here.
In response to what he says that your environmental study aspect of this is finished.
I mean, that is true, Your Honor, and it's true of every case, of all of the litany of cases that we've cited that hold that secret is a preliminary step and that is not challengeable as final agency action. In all of those cases, the secret process was finished when the decision was challenged, and the courts have uniformly held that the action does not become ripe for challenge at that point if there is something like the enactment of additional legislation or additional agency action.
So, I'm sorry, I didn't mean to stop you in the middle of the thought, but I want to get to sort of wrap up about this because I'm having trouble reconciling it. So if it's true, and I think you agree that the temporary order is something different, that's different, and I think you would agree that the reason that the temporary order came into existence was because of an emergency, and that certainly it could be challenged on the basis that no emergency is ongoing. There's no need to keep it in place, right?
That's certainly the challenge that they're bringing, yes.
Okay, and that's not something that goes back to the original enactment of the temporary regulations, the temporary program, right?
I'm not sure I follow what you mean by what it goes back to.
Well, in other words, it's like it couldn't be untimely because it would be dependent upon when the emergency ceased to exist. I know you don't want to give up the ghost in the suit that's pending, but I think you gotta speak with a consistent mind here. So here, but I'm going to get to my point here. The EIS, as I understand it, said, gee, there's no environmental impact because whatever we are doing is going to be better than what we did in the temporary program, using that as the baseline. Is there a problem with that? Because, in fact, that was due to an emergency and that the baseline should be otherwise in a non-emergent setting. What would be the environmental impact?
So, Your Honor, that's actually an excellent point because if you read the EAS, the no action condition that it compares to the permanent program is actually not the temporary program. It's the pre-existing sidewalk cafe program that existed for years before the COVID emergency. The EAS takes the experience of the temporary program and has some things that address some of the issues that have come up with the temporary program, but in terms of the comparison, the no action and with action conditions, it compares the pre-existing sidewalk cafe program from before COVID.
Don't you sort of have the permanent program going based upon the fact that this pre-existing temporary program and the foundation for the temporary program no longer exists? And now you say when they seek to challenge it, it's premature.
It is premature. The permanent program does not exist yet. There's still, it's been delayed largely as a result of this lawsuit, but there's still...
But not everything is closed down because the temporary program no longer has a basis.
We would argue, we will argue in the separate action that the temporary program still does have a basis to continue until the permanent program goes into effect.
And so, counsel, may I ask you, are you saying that you can use the EIS in the lawsuit about the temporary program as an evidence supporting your view?
I don't think the EAS would have...
EIS, I'm sorry.
I don't think the EAS would have... I can't think of a way the EAS would have any bearing on that lawsuit. I mean, maybe some evidence that was uncovered in the course of doing the EAS might be relevant, but other than that, I don't see it having any bearing on the separate lawsuit.
And so you're saying that you couldn't use that as a sort of sword in another lawsuit when you're not allowing the petitioner to challenge it in this lawsuit?
I mean, I hate to cabin the creativity of my colleagues in the Environmental Law Division, but I can't
Well, I
take
mean,
away-
it's important. You can't have it both ways. Either it's not fine, you know what I mean?
Right. No, but the EAS does not evaluate the environmental effects of the temporary program. It evaluates the potential environmental effects of the proposed permanent program, which is quite different in a lot of ways. So I don't see it being relevant.
Sir, assume for a second, just assume for a second with me, that SECRA was violated with respect to the permanent program in the manner in which the petitioners are alleged, okay? Is there anything that the city council or the city administrative apparatus can do that would ameliorate the SECRA violations?
Well, that goes to exactly why this is not a ripe challenge, because there are going to be additional rulemakings. There's going to be implementing legislation from the council. As public comment comes in, the exact contours of the program may change. And we've said throughout, the rules require this as well. If there is a significant enough change that
You're
additional...
not really responding to the question, does it remedy the SECRA violation?
Would it remedy the SECRA violation if they ameliorated or changed the program? Is that...
Anything that happens subsequently, how is that going to ameliorate the pre-existing SECRA violation?
Well, there's no cause of action just for a SECRA violation without an associated impact on a petitioner. So if you look to the decisions in cases like Edie, it's talking about how whatever impact that might flow from the ultimate decision can be ameliorated as to the petitioners. There's no direct injury by a SECRA violation to a given petitioner until there's some agency action that implements something that harms them.
So if something is implemented and it's different than what they considered in doing the environmental impact evaluation, how does that challenge go?
Well, Your Honors, there can be an evaluation. It depends. The whole problem is the case is not ripe, so we don't know how it's going to go. Depending on what the changes are, it could require additional environmental review, as we concede freely throughout our briefs. It may not require additional environmental review. It may have likely less environmental impacts than the reasonable worst case scenario analyzed in the EAS. So it's exactly why the case is not ripe, because it's impossible to know without knowing what the changes might be, what additional environmental review, if any,
Hardly
might be
provides
required.
incentive for a quick final decision.
Sorry, Your Honor?
Hardly incentive for the city to provide a quick final decision.
Well, I believe there's still incentive to make a quick final decision because it's a popular program. It saved hundreds of thousands of jobs, and people want it to be implemented. And we've been working hard to try to implement it.
We've got the temporary program right now serving as sort of a Band-Aid, right? It's not that there is no program. There's a temporary program that's ongoing. And now we have the permanent program, the contours of which are starting to take shape.
The city would like to move to the permanent program as expeditiously as possible.
Okay, thank you.
Thank you, Your Honors.
Thank you both. Okay, the next case for argument is Mcdaniel versus City of New York.
Not sure we should all sit or,
What
do you want to go
who's
first?
arguing well, I think the City of New York I had marked first.
Okay.
So the City of New York will sit and the appellants, well, go up to the podium. And we'll take it from there. Don't worry. You know what? We know who you are, notwithstanding that you may be standing in the wrong place, okay? Okay.
Good afternoon, Your Honors. Kevin Pollack from Fabiani Cohen Hall on behalf of the City of New York. It is submitted that the lower court's order should be reversed since the city proved that it lacked prior written notice of the crosswalk defect that the plaintiff claims she tripped on. which was described anywhere from an inch to an inch and a half crack in the crosswalk. While the court correctly determined that the Big Apple map did not provide the city with written notice, the court incorrectly denied the motion, finding that...
Why doesn't that map provide the city with notice? Why doesn't that map provide the city with notice?
As in the Donofrio case, which originated here, went up to the Court of Appeals, there are photographs taken post the map and pre the fall that show there is no defect. So in other words, the 2003 map, which was 11 years or so before the accident, was essentially mooted or becomes irrelevant by the post-map, pre-accident photos, which show that there is no defect. And that's why it is believed that the map...
And when did you first make your case as to that the Google Maps absolve you of liability? Was that first in your reply?
The map was included as part of our motion. The argument was that there was no prior written notice based upon the DOT record search. The map was not brought up until the plaintiff brought it up. I mean, we didn't bring it up because if it didn't show anything, I'm not sure, I don't believe we have an affirmative obligation to argue in the negative. But the map was highlighted by the plaintiff in opposition and then in the reply. I mean, it was part of the motion, but was not directly an argument in our moving papers.
Well, it was a little more than that, wasn't it? In your underlying motion papers, wasn't the image embedded in your affirmation and submitted for ease of reference only? With the tag underneath that it was, this image is being submitted for, quote, ease of reference only, end quote?
Your Honor, quite honestly, I don't recall that language, but it was certainly relied on as proof that there was no, I'm not sure the phraseology, but there was certainly an argument made by the city that these photographs show that there was no defect. Again, you could be correct, I'm sure you are correct, but I don't recall that phraseology myself in the original moving papers.
Wait, are you saying that you didn't argue in your motion for summary judgment that the map didn't show a defect?
In our initial motion,
you said this map doesn't show a defect.
I don't believe that was made in the initial motion.
You made the city, you moved from a summary judgment, you argued that the Big Apple map did not notify it of the particular defect at issue, correct? Isn't that what you argued?
That was the thrust of the argument.
Well, you did argue it in your moving papers, and you didn't put in the Google photograph that says, and whatever that was in 2003.
Correct. The Google photographs were not used until the reply in response.
So all you said was, this map doesn't show that defect. And then the plaintiff comes back and says, yes, it does. Here's the square and the line and the green thing. And then on reply is the first time you say, yeah, maybe it was there in 2003, but here's some Google Maps that show it wasn't there in 2008, right?
The sequence, as I recall it, Your Honor, was that we argued in our initial papers that there was no prior written notice. The Google Maps were certainly not part of the initial moving papers. They were submitted in reply in response to the plaintiff's argument that the map did show a defect.
But you did argue that the Apple map didn't show. It wasn't like nobody talked about you didn't talk about the Apple map, and then the plaintiff brought it up in opposition. You talked about it in your moving
Yes, we said there was no prior written notice.
Okay, all right. We know you have further arguments. We're going to
Thank you, Your Honor.
consider all
Thank you
of
for your
them.
time.
Thank you. All right, let's have Liz argue next.
Good afternoon, Your Honors. Robert Emmons on behalf of Carla Lizza. We're seeking to have overturn the reverse the summary judgment decision that was denied as to Carla Lizza. It is undisputed in this case that the plaintiff fell in a crosswalk on 187th Street. It is also undisputed that our client, Carla Lizza, never did any work on 187th Street in that crosswalk. The evidence that was presented through the deposition testimony of Robert Darpa, also through the testimony of the city witness, and also through city records, shows that everything that Carla Lizza did was on Webster Avenue. They did milling work only, They did it a year and plus before the incident occurred. They never touched the crosswalk. That's corroborated by city records that said in the crosswalk that where the incident occurred, in the segment records, that there was never any milling, there was never any capital improvement project, which is all that Carla Liza did. It milled the road that was adjacent to where the incident occurred, but never touched the place in question. Plaintiff in this case has never presented any evidence, despite the summary judgment decision, that somehow our work caused the defect in the crosswalk that we never touched and we never did any work in. So we believe for all those reasons that the summary judgment decision was incorrect, and we respectfully ask the court to overturn that decision.
Okay. Thank you. Any questions, colleagues?
Thank you.
Thank you. All right. Triumph next.
Good afternoon, Your Honors. May it please the court. Michelle Gelman for Appellate, Triumph Construction. Again, it's undisputed plaintiff's trip and fall was in the crosswalk of East 187th Street. Triumph did perform work back in February of 2009 as a subcontractor to another defendant, in this case, Stepmar. It came in and did some excavation work. Thereafter, its trench was backfilled by Triumph. That particular work, those records were provided and also testified to, clear from the testimony and the record itself that that work by Triumph was completely on Webster Avenue against the curb line. In fact, my witness was also shown another work document, a Con Ed field document or an opening ticket for work that was performed subsequent to Triumph and actually extended not only into the crosswalk, but through the middle of the crosswalk, where plaintiff identified on photographs that are part of the record where she fell. My witness was
What was the nature of the work that Triumph did?
It was involving some electrical conduits, and usually what we do is we dig up the roadway, we put in the conduits. This is a trench that, in this case, I believe it extended 2.3 feet by 4.5 feet.
You don't cover up that trench. You don't pave up. It's not part of your work to cover that trench or to pave over the trench, right?
Yes and no. We backfill it, and then at that time, my client did not do the final restoration or paving. Another company would come in and do so. The issue in this case for Triumph is that our work, again, was only on Webster, just coming up to the intersection of 187th Street. The plaintiff is clear in photographs. It's in the crosswalk of East 187th Street where she trips and falls. She's identified several of them that are part of the record. And again, there was more work done in or around that area of Webster and 187th Street at the end of March of 2009, specifically by another contractor. In fact, the contractor that hired me, but that particular work at the end of March of 2009 in the East 187th Cross Street was done by that contractor. It wasn't subbed out to my client. So it's our position the lower court's decision should be reversed.
Any questions, colleagues? Thank you.
Thank you.
Okay, the plaintiff?
Good afternoon, Your Honors. Plaintiff only appeals from the portion of the order that found that the Big Apple map did not provide sufficient prior written notice to the city. In the city's motion for summary judgment, they did annex the Big Apple map, said it did not show a defect, but a plain reading of the viewing of the map along with the key shows the two squares with the line in between showing an extended section of potholes and other hazards in this crosswalk.
That map is from 2003. The Google map is obviously a lot more recent. Why doesn't that refute this prior written notice that you point to from the Big Apple map?
A couple of things on that. One, that was submitted for the first time in reply. Two, the photographs, the way in the form they're submitted, you can't see the date as it is embedded into the reply affirmation. I think in the form that they are submitted, they're without probative value on this. At trial, I also think a jury could look at those pictures and draw a different conclusion. than the city. I'm not sure, looking at those photographs, that particularly in the form they are provided to the court and in the record, actually shows there's no defect in that crosswalk. I don't think that can be said based on the photographs submitted in the record. I think a jury could look at those photographs and draw different conclusions.
You mean that even the Google map shows a defect? Is that what you're
Possibly,
saying?
potentially. I think someone could look at that and argue that there is a defect in there. And there's also two defects we're dealing with. Her right foot tripped in a crack in the crosswalk, and then there was a depression. So when her right foot hit the crack, she stumbled forward, and her ankle turned into this depression. So there's actually two defects side by side in this crosswalk. And the Big Apple map shows an extended section of potholes, and there's no record of any repair by the city. And they never came forward with any records that that defect, as noted in the 2003 Big Apple map, was ever repaired. It's our position it was their burden to establish their case on summary judgment, and they did not. And even if the court finds they did, there's a question of fact.
Okay, why don't you address the other defendants as well?
Sure. So as far as Lizzo's work within the area and the vicinity, which they do admit that it was in the proximity and the vicinity of the crosswalk, their own submissions also fail to meet their burden as the moving party. There's a diagram that was shown to the witness that has a pink line through it that shows where the work was performed. By their own map, the milling work they did would go through that crosswalk. Now, the witness had marked himself where he thought the accident was on that same map, but he was wrong. That's not where the accident was. So relying on the witness's own marking of where the accident was does not, Mr. Diarpa's deposition to be specific, does not actually show that they didn't perform work in that crosswalk.
But counsel, the plaintiff says, I fell at 187th Street. I mean, she says where she fell, and there's nothing adjacent to that that Lizzo did work on.
Well, if you look at the, on page 7.
I'm looking at the photographs. I'm looking at where she said on the photographs. She said she fell on 187th Street, not in the area where, and plaintiff and Lizzo, there's nothing that says that Lizzo did any work near there.
On page 1766 of the record, there's this diagram that was shown to the witness, and the pink line in between is the area that that Lizzo did their work. And that would encompass the 187th Street crosswalk with Webster. And then on top of that, we don't have the daily logs from Lizzo to know what work was actually done, and I don't believe we have the contract either. They were unable to locate that. Quickly, as if you want me to just address Triumph, it's similar in the sense that, again, their own submissions raise a question of fact. They dug a trench that I believe the witness...
Can you give me that page number again that you think creates an issue of fact?
Sure.
About whether there was milling work done?
1766.
I'm looking at that. I don't see what you're talking about.
See the pink line in between the blue and the green line?
Yeah, I actually don't, I don't have it in color here. You know, but there are two 187th Street crosswalks, right?
Correct,
You know,
yes.
there's one in the south and one in the north on Webster, right?
Yes, correct.
Okay, because it's not straight across. And she claims that she fell on the southern one, right?
No, so where that X is on here is not where she fell. She did not mark this. That was the witness for the defendant who marked that, and that is the wrong location of the accident. It's actually the other 87th Street on the western.
She fell on the north side?
Yeah, northwest side. So it would actually, if, you know, by the witness's own testimony as far as the milling work in that center line, it would in fact go through that intersection.
Oh, you have it in color, thank you. All right, he said that you're saying the pink line is where he said he did the work?
Correct. Correct, and that notation of where the X is, that's from him, not from the plaintiff.
Okay, thank you.
And then on Triumph, also, as far as that, there is a separate record on appeal for Triumphs because there was a separate order. 554 of that record has a diagram that was again shown to the witness, and the witness did say that a portion of that work encroached on the crosswalk of 187th on the right-hand side of that diagram, and that is where the client fell as well. on the northwest side of the diagram on page 554 of the record as far as Triumph's appeal is concerned.
Okay, thank you.
Thank you.
Okay, let's hear our rebuttal. Let's start with the city.
Just very quickly, Your Honor, I just want to make the point that the plaintiff does not contest that the city can be liable for Carlo Liz's conduct. I mean, that was a point in our brief. The plaintiff has not contested that. So no one's contesting that except us. So the plaintiff's case is based upon the map only. And the second thing is, I think if you do look at the Google photograph at 1795 in the record, it does show that there is no defect as depicted in the Big Apple map. Again, that's 1795. It's the top Google photograph taken July of 2014. Thank you.
Thank you. All right, Liza?
Very briefly, Your Honors. Our client was shown, the one who testified, Mr. Darpa, repeatedly the pictures of the crosswalk where she fell. He emphatically said more than one time that that picture of that crosswalk, they never did any milling work. He said it was outside their contract limit. The city documents corroborate that. There was never milling work done in the crosswalk where the plaintiff fell.
So what do you say about 1766, the record at 1766?
That was a picture that he drew, which he was confused on, but the rest of his testimony, when he's shown the exact location of the fall, he is emphatic, and the city testimony and records corroborate that.
So
do you agree?
He says,
I'm sorry.
So his testimony is to the effect that none of the milling work was done in either of the crosswalks.
Absolutely. Not only is it his testimony, but the city records clearly show in the segment search there was never milling work done in the 2 years prior to this incident, which includes our time period in the crosswalk.
Thank you. All right, Triumph?
Your Honors, I do again want to point to the record, page 554, which is the only document plaintiff assumes shows my client did work. First of all, the client's testimony, Triumph's testimony, was along the northerly curb of Webster that extended into the intersection. And if you look at where point A is, that's the intersection. There are no cuts, as you can see, where there would have, the crosswalk would have been.
Yeah, isn't necessarily the crosswalk.
Correct. In other words, and also.
And and when in relation to the accident, how far before the accident did your client do this work?
Just over 5 years, February 20th of 2009. And one other thing I'd just like to say is the one thing, again, plaintiff has failed to point out that's clearly part of the record, is there is another Con Ed field ticket or their opening ticket that shows another contractor in March of '09 was specifically in the crosswalk and also the middle of the crosswalk, which per pictures is where plaintiff fell. Thank you.
Thank you. All right, plaintiff.
Just as to address again the Google Maps photographs, again, the date is not clear from the submission to the court. Also, I still think the photographs do not actually depict no defect as set forth by counsel. Also, to the extent plaintiff testified to a slope and an uneven surface of the crosswalk, that may not be depicted, or especially in the size of the photographs submitted, you may not be able to see that in the Google Maps photographs. As far as Triumph's statements about the testimony, he did testify that they cut a trench that's in the crosswalk or the intersection that was 7.5 feet deep. And then he was shown on the Plaintiff's Exhibit 1 and that diagram again on page 554, and he said it's showing it on the north side of the drawing, which is the right side of the drawing, and that's on page 493 to 494. So on the one hand, he may testify, oh, we didn't do anything in the crosswalk, but then he's also testifying we did encroach the crosswalk, and it was on that side of the diagram where plaintiff fell. So it's at anything, it's a question of fact, it's an ambiguity. And same with to the extent the witness maybe was confused, he should be subject to, for Lizzo's witness, subject to cross-examination at trial, as to explain his testimony to a jury to see if they find it credible or in line with the diagrams. It's ultimately their burden to eliminate questions of fact, which there remain many.
Thank you. Thank you
you.
all, counsel. The next case is Skeet against Greyhound Lines. Okay, you may proceed.
Good afternoon, Your Honors. This is Jason Steinberg from Fleishner and Potash. I represent Appellant A&L Cesspool. Judge Adams, in her decision, is improperly expanding the scope of an independent contractor's duties under the law by requiring or essentially holding that my client should have done something more or something extra to make the area safe when that was outside the scope of their contract. That's what this holding does, and the law is very clear in New York. In this department, independent contractors owe no duty to third persons unless there's 3 circumstances present. One of them is whether or not they launch a force or instrument of harm, and that's really the issue on this appeal because it's undisputed, as a matter of fact in this case, that my client didn't create the dangerous condition. It's undisputed that they didn't remove the cover and failed to replace it. All that has been, it's undisputed. So the sole issue on this appeal is whether or not my client's placement of a piece of cardboard back over the hole is launching a force or instrument of harm.
It's application of Espinal. How you apply Espinal.
How do we apply Espinal?
That's what this case, that's what your appeal is about, how we apply Espinal. Does Espinal apply to
Espinal applies to the extent of the evaluation of whether or not the independent contractor breached the duty. So, and the sole factor.
It's your position that you didn't put a force of harm, you didn't launch a force of harm by this.
No, he did not launch a force or instrument of harm merely by keeping a condition exactly the way it was before he got there. All right? To hold that he launched a force or instrument of harm by putting something back where it was, you're expanding the scope of the independent contractor's duties because my client did not have a contract to repair or maintain that pump room.
Right, so your argument, you're not arguing that this wasn't a force of harm, the condition. You're just saying that your client didn't, quote unquote, launch it. You knew about it. You knew about it, clearly.
Yes, that's part of the argument. But by holding, the way Judge Adams did, by holding, there's a question of fact as to whether or not we exacerbated the condition. You're now, in other words, she said we should, my client, Mr. Oliver, should have left the cardboard off because at that point it was an open and obvious condition and really what's a bit of a confusing holding. But to say that he should have left it off, you're creating an obligation that does not exist as far as what his obligations were.
Just to turn your attention to something else. Greyhound has claims against you, correct? Cross claims, indemnification.
Yes.
You didn't address that on appeal.
I addressed it on appeal in the reply brief when they.
On your main brief.
I'm sorry?
On your main brief.
In the main brief.
Yeah.
We asked for a dismissal of all the claims and cross claims, but if the claim of negligence is dismissed against my client, which it should be, then common law indemnity is moot as a matter of law because you can't get common law indemnification if there's no negligence. And in this case, there's also no contract that exists, so you can't get contractual indemnification. If the claims are dismissed, it's moot. And I think it's been sufficiently addressed, and that's really, unless there's any other questions about the indemnity part, I think it's pretty clear in this case that, and that Soteriba, I want to touch upon Soteriba. In Soteriba, this court held that a subcontractor who had an obligation to barricade a staircase that was dangerous did not have a duty to secure the hole itself in the stairwell. The court said your obligation really was just to barricade the area, so even if you didn't barricade it, you had no obligation to secure the hole. That's what the court said, because the court, well, you guys didn't want to find or expand the scope of the subcontractor's duty, which is just to barricade the area. So, and if you, in the end of the decision, this court said, even if there was no barricade, the subcontract did not displace the general contractor's obligation to maintain the premises. Similarly, in this case, A&L Cesspool had to clean the tank, They did not displace Greyhound's duty to maintain the area or Greyhound's preferred contractor, Lawrence. If there's a holding that there was an exacerbation simply by keeping something the same, that is expanding the scope of the independent contractor's duties, and it's well-settled precedent that we don't do that. Thank you.
Great, thank you. Let's hear from your adversary.
Good afternoon, Your Honor. Stephen Saul, Greyhound Lines, may it please the court. So counsel is continually trying to make this a duty issue where we think that Judge Adams correctly ascertained the issue here that once that piece of cardboard is removed, there is now an open and obvious potential hazard, this hole in question. Mr. Oliver did not need to put it back there. Once he did so, he took an act, he acted overtly, he created a duty for himself to act as a reasonably prudent person would need to act in this situation. And a jury could certainly infer that a reasonably prudent person would not take a piece of cardboard and place it over what would be considered a potentially open and obvious defect.
What was his duty to the plaintiff? Was it under Espinal?
His duty to the plaintiff, I am not arguing the issue of whether or not he owed a contractual duty to the plaintiff.
Well, he
That
didn't.
I don't think is the
right.
issue.
No, the issue, we're talking about a tort duty. He didn't have a contractual obligation to the plaintiff. We know that.
Yes.
Right. So where does the duty derive from? Is this an Espinal case?
His duty derives from a common law duty to act as a reasonably prudent person. He is in there performing a duty. The fact that he is there, that he sees a piece of cardboard over where he...
No, wait. What do you mean he's there performing a duty? What do you mean by
he's
that?
performing a
He has no
service.
duty at all to the plaintiff, none.
He's performing a service.
And he doesn't do anything to change what is already there. He was the way he was when he got there, it was the way he... So what do you think he's supposed to... Where is the duty that you're saying to make it better come from?
I didn't say he's there to make anything better. That's
Well, so
why
if he left it exactly the same, where is the breach of a
But
duty?
he didn't leave it exactly the same. This is not a situation, this is not a condition that he observed, and that counsel cited in the...
When he got there, the piece of cardboard is over the hole, right?
Correct.
He did his work, and he left the piece of cardboard over the hole. How did he change that?
Because this was not a condition that he was there to just observe and not address. It separates...
Okay, then I'm going to ask you, what duty did he have to address that condition?
We had a duty once he opened it up and showed that there was an open hole.
You're saying if I walk along the street and I see dirt on the street or garbage on the street, I have an affirmative duty to go over and clean it up and make it better?
He's not picking it up. He's placing the concealing device back over the hole.
Again, leaving it exactly how he found it. Not any different. You're not arguing that he left it any different than he found it. And you're not arguing that he had any duty to fix it originally. So I'm still trying to figure out where that duty came from. He doesn't have a contractual duty. He doesn't have a common law duty to make it better than what he found it. So where's the duty?
I think we're treating this as one combined action, and it shouldn't be. Once he takes the piece of cardboard off of the hole, we have an entirely different situation. We have him observing a hole that somebody, if they didn't know was there, could be a potential hazard that they could fall in. As soon as he takes the affirmative duty to place that piece of cardboard back over a hole, he has now created an entirely new potential hazard that did not exist before he placed the piece of cardboard.
How is it different from the 5 minutes before he got there? How is the danger different than the danger that was there than 5 minutes before he got there?
But respectfully, Your Honor, I understand that the condition
I'm just asking you, how did it? How is it?
I don't think that is the relevant question, respectfully. I think the relevant question is, could a jury infer that a reasonably prudent person, whether or not he's there pursuant to a contract, he's just there as,
Can I stop you for a minute? I respect that you don't think it's a relevant question, but when the judge asks you a question, answer it, and then you can go on with your argument. So is you're conceding then that the condition is exactly the same as when he found it?
Yes, we're not conceding that the condition changed. We're but I
Well,
think, again, that's treating it as if it's one
Yeah,
combined.
wait, you know, I know your but, and you'll get to your but. We're giving you a lot of thing on that, but we want to just find a universe in which we're all agreed. So there's no question that the condition is no different than when he found it, correct?
Yes, Your Honor.
Okay, so now make your argument. Why doesn't that matter?
It does not matter because once Mr. Oliver removed the piece of cardboard, the condition he found it in is irrelevant.
So his duty only arose because he removed the cardboard?
His
and
duty.
Created a safer condition, and then then he had a duty not to make it less safe?
He had a duty not to create a hazard that in the moment after he took that piece of cardboard away no longer existed.
Sir, would you agree that if Mr. Oliver didn't do any work that day, hadn't touched the cardboard, hadn't been in the area, plaintiff's accident still would have happened?
Hypothetically, I believe that could have been the case.
Okay, all right, thank you.
If you're,
All right. No,
I apologize,
you're out
Your
of
Honor.
time.
I do want to address the.
You're out of time, right?
All right.
All right, let's hear rebuttal. We have your briefs, so not to worry.
There was just an incorrect statement.
Just going to touch up on one thing. Counsel keeps saying that a jury can infer, but at the end of the day, there's no factual dispute in the case. So the issue before you is really a matter of law. So the jury doesn't have to figure out whether or not putting it back on creates some kind of an obligation. That's really a legal issue for the court.
Did Mr. Oliver recreate a dangerous condition by removing it and then putting it back?
No, it keeps it exactly the same it was, and you don't have an obligation. What this amounts to is inaction, which is at most a refusal to become an instrument of good. That's really what it is. And the courts have said multiple times that's insufficient.
By removing it, when he originally removed it, did he make that condition safer?
It's impossible to know that. No, because the cardboard apparently, we don't know that. We don't know the answer to that. If you're keeping the condition the same, you're not making it worse. By removing it.
He did do something, right? He removed it. Did that make the condition safer at that time? I mean, the gist of your adversary's argument is that when he removed the cardboard, he created a safer condition that then he made unsafe by putting the cardboard on. Well, what's wrong with that argument?
I think, well, because by putting the cardboard back, he basically put the condition back the way it was. So, first of all, it's also speculation because you're assuming that it was safer without the cardboard on it. There's no proof that it was.
Well, more fundamentally, by removing the cardboard, did he take it out of Espinal? Did it then become a general negligence case as opposed to Espinal? Because then we don't get into whether it's safer or not. Now we would get into a more general, reasonably prudent person, reasonably prudent actor standard, right? So by removing the cardboard, did he take it out of Espinal?
Did he?
Or does the framework or the lens through which we review this remain and consistently stay Espinal?
The condition remains it's still a dangerous condition. It's supposed to have a steel cover on it, okay? Putting cardboard over it, removing the cardboard doesn't make anything less safe or more dangerous, okay? And there's no proof, and the cases do hold that we rely upon, that when you don't make something less safe, you haven't launched a force or instrument of harm. If you're making it less safe, okay, then there's an argument to be made you launched a force or instrument of harm. But to say that by removing the cardboard, it was safer is complete speculation. And you can't do that in opposition. You can't oppose a motion based upon speculation. So I don't think it's fair to say by removing it, it was safer. There's no proof of that. And that doesn't come down, and in any event, it's not up to the independent contractor to ascertain what's safe or not safe because it's not their obligation to maintain or repair the area.
So what you're basically saying is it may change your duty to warn, but it doesn't make the condition itself any better. There's still a big hole there, right?
Correct.
It's not correcting the situation. It's just maybe affecting a duty to warn.
Okay. And another thing I want to point out is that,
Well, you're out of time, too.
okay, thank you.
No, I'm holding people to their time for obvious reasons today, but we have your briefs, and we have the record on appeal, so we'll be able to otherwise parse out your case. Thank you.
Thank you.
Thank you both. The Far East versus Friedland. Okay, you may proceed.
Thank you, Your Honor. Jeremy Honig, Rifkin Radler for DFAW East. Your Honor, the trial court incorrectly denied DFAW's motion for summary judgment on breach of contract for breach of the license agreement against defendant Friedland. In the order, the judge incorrectly limited the obligations of Friedland pursuant to the license agreement. What the judge said was that the license agreement, quote, merely requires Friedland to take cautions to prevent damage, end quote. That not only is a misapplication of the actual language of the agreement, but it misstates DFAW's position in the summary judgment motion, which cited to many more provisions of the agreement that Friedland breached. Specifically, there was an obligation by Friedland if there was damage to the building, to the neighboring building, which is DFAW's building, that is caused by the work, that Friedland is responsible for immediately repairing that damage and must restore DFAW's property to the condition that it was in prior to the work being performed. The trial court does not address those provisions of the access agreement at all, even though that was specifically part of DFAW's motion for why there was a breach of the access agreement. What the judge did find...
Can I ask you a question? Until there's a determination, I mean, the judge found that there was a violation of the statute, strict liability, with a hearing to determine the extent of the damage that was otherwise caused by the violation of the statute, correct?
Yes, there were two different motions. So you're asking about the statutory strict liability.
But I am,
Yeah.
but it's a lead into the breach of contract, which is your question, because what the judge said is, you know, the statute is one thing, but the contract is kind of different. And you read the provision about how the obligation under the contract is to restore the building to the condition it would have been in, or it was before the underpinning excavation work was done, right?
Before any work was done, yes.
Well, we're talking about the excavation, no?
Well,
that actually makes my point even stronger. How can you adjudicate the breach of contract then until you otherwise understand the scope of what happened as a consequence of the strict liability under the statute? You know, and I'll allow you this, that it's a little bit of a head scratcher, and I'm going to ask your adversary about this, about how you tease apart the contract from the strict liability, but that's my question to you. Is this a point at which they could be distinguished as elements of causes of action?
Yes, Your Honor, and I actually don't think it's a head scratcher, and let me explain how that can be reconciled with one another. You have the strict liability statute that essentially says, if you're performing excavation and your neighbor's building is damaged and you're part of the chain of the excavation, you are strictly liable. That's what the statute says. Now you have a contract that says, if you damaged your neighbor's building, your neighbor's giving you access, you do work, and you damage your neighbor's building, you have to repair it. Those are two independent things. So what the judge found specifically at page 13 and 14 of the record in her order, quote, it is also clear, page 13 first of the record, quote, there is no question the evidence demonstrates that defendant's activities damaged plaintiff's property to some extent, period, end quote. It is now law of the case that whether there were 1%, 50%, 100% was caused by defendant's work. And then the judge says on 13 on to 14 of the record, quote, it is also clear defendants knew and admitted that their construction activities had caused damage. So with that issue being resolved, they caused some damage. Now you look at the access agreement. The access agreement says if your work damaged the property in any way, you must repair it. You must restore it to at least as good a condition as it was in. You must repair it. You must indemnify DFAW. Now, what they attempt to argue, and unsuccessfully, because their experts were unable to affirmatively say that there was any other cause, but they attempt to argue that some work that was done years before by DFA's tenant contributed to the damage or caused the damage. I don't agree, but let's assume for a second that they're right. That only goes to damages. How much do the defendants cause the damage and are responsible to pay, or how much?
Except, right, if their argument is that regardless of our damage, this would have happened anyway, and that's what their expert says, right?
That's not what their expert says.
Well, I mean, that's what they argue, that this was not caused, this was caused by the previous, you don't think that that's, you don't think
that's not a, if you look at their expert affidavits, that is not what
well,
they
let me
say.
ask you this. Do they at least argue that's what their expert says, or are you saying no?
No, at no point do they argue that my client, or not my client, the prior work was the sole cause.
No. The question is, the obligation is to put the building in the same position it would have been had the damage not occurred.
That's not what it doesn't say the same position it would have been.
Oh, what does it say?
There's two separate clauses. One says if you damage the building, you have to repair it.
Right.
That's one. There's a separate that says you must restore the building to at least as good of a position as it was in prior to your work. Not what it would have been or what it was in. So if
the damage was caused by Goriad's work in 2006 and 2014, you'd have to repair that too?
No, that absolutely not. They're only required to repair damage.
So don't their experts set up that factual issue?
No, Your Honor. What they're, and that's been resolved by the judge in her decision. She said there's no question that the defendants at least caused some of the damage. There may be a question about whether there was some other cause, but she specifically says that doesn't save the defendants for the strict liability. She should have gone on to say that it also doesn't save Friedland from contractual liability, but she didn't go to the operative clauses of the agreement that we had argued in summary judgment that they breached. She only talks about the clause that has to do with taking steps to prevent damage.
Sir, under the strict liability law, was it enough for you to demonstrate as a matter of law that someone's activity within the chain of the excavation activities caused damage, and thereby exposing all of these defendants to liability?
That's correct.
Or did you, I'll take it.
Yes.
Or did you have to demonstrate discreetly as to each defendant that their conduct or inaction was a proximate cause, or whatever the appropriate causal test is under this strict liability statement? Did you have to drop down and get more nuanced and address each defendant's, the causal relation between each defendant's activity?
No. All we needed to show was that they were in the chain of of the companies that were performing excavation work. So you have Friedland and the Madison entity, that's the owner and the managing company. And then you have the GC, and you have all the excavation subs that performed excavation. That's the whole point of the strict liability is you do work, the building's damaged, let them, they can fight out their indemnification and their cross claims against one another all they want. My client doesn't have to do that.
Could someone at the trial for the strict liability offense, the apportionment trial, assuming that we find that that's appropriate, could someone be found 0%? Could someone be 0% on the verdict sheet? Or would some measure of fault have to be ascribed to each of the actors?
I would say that at that point, so you have a finding of strict liability, and then a jury is going to determine which of the entities actually caused the damage, and the damage will be apportioned accordingly. And so the judge was right there on the strict liability, but she should have done the same thing on the breach of contract. Finding of liability and the open question on damages, if they want to say that there might have been some other cause, they're free to do that, but that goes to damages only.
Okay, thank you.
Thank you.
All right, let's hear from Friedland.
May it please the court, my name is Michael Caulfield. I represent Friedland, JRM, and 706, the construction, essentially the construction manager here. Admittedly, we've got two inconsistent rulings by the court. It may sound simplistic, but I think that's what we have. One on the breach of contract, where the judge denied plaintiff's motion and gives my client an opportunity to argue to the jury that there was no breach of contract here, that the jury has to decide whether or not...
Let me stop you for a minute, because I think that this really is at the heart. So you would agree with your adversary, at least to this extent, that the strict liability and the contractual liability are like hand in hand. It's either yes as to both of them, or it's no as to both of them, right?
Yes, Your Honor. It's my client's position that the jury should get both questions.
No, but is it your position that as soon as you say breach of strict liability, that means breach of contract? Or can there be a violation of the strict liability requirement, and that may not rise to a breach of contract?
I think a jury has to get both of those questions. I don't think that they're inseparable. I think a jury could find a breach of the statute.
You haven't really answered my question or Judge Friedman's question.
I'm sorry.
Which is, suppose we don't agree with you and we think there's strict liability. We think that decision was right on the money that she did. I'm not saying we are. Does it follow in your analytical look at this case that then you lose on the breach of contract with the only issue being damages, as your adversary suggests?
My answer is no, because a jury should still be entitled to determine whether or not we took such precautions as required. Now, it may be a moot point, because if we lose on strict liability, you know, the jury will have to decide on the verdict sheet about damages as well. So it may be not a moot point, an academic point.
How could you be liable on strict liability? And let me put the question this way. How could you be liable on strict liability but not liable on breach of contract? Is that possible?
Oh, just like in any other case, you can have statutory liability, such as under the labor law, and you could have or a breach of contract. They're separable.
You can theoretically, but
Right.
what's different here?
Well,
what's different in what obligations exist in the contract that are different, that are not reconciled by whatever you do on the strict liability statute?
because the language of the contract, such as the such precautions language, is different from the language of the regulation or the statute.
Could you give us an example how practically that would play out in this case?
In front of a jury?
That it's strict, in front of a jury, that there's strict liability, but there isn't breach of contract.
Well, it may be academic, but how it would play out practically would be that the jury would hear the language of the administrative code and be asked to determine whether or not there was cause, whether or not, and I have the statute in front of me, whether or not we did what was necessary to preserve and protect,
And it's our position that they should be entitled to make that decision. The judge shouldn't take that away from the jury. And on the other hand, a jury would get a separate breach of contract charge from the PJI, which would require them to determine the breach of contract. And my client would be able to argue that we took such precautions in the face of the groundwater and the excessive dewatering, and that we did all that was required under the contract. So I think it's separate, but I can see that it may be an academic distinction on liability. And I would just, if I may have one more second,
So there could be summary judgment on strict liability, but not necessarily on breach of contract.
That's what Judge Crane decided.
Right.
You know, we're arguing.
That's what we're looking at.
Right. We're arguing that she was wrong. But also, you can read into her decision, I think it was Judge Higgett who said, we could be found 0% under her rationale. So let us give an opportunity to the jury to find that.
Okay, thank you. All right, let's hear from the defendant, Scalpel.
Good afternoon, Your Honors. In listening to what the arguments have been, I do want to take possibly an extra minute to discuss the issues of the reconciliation of the issue of the agreement vis-a-vis the strict. Just generally speaking, the procedural posture of this case was that the judge had 4 different motions in front of her and split them up. There was a contractual indemnification motion from Friedland to Scalpel, and this court already made a decision in that case that at the time, Scalpel does not owe any indemnification, specifically because it hasn't been proven that it was negligent or that the alleged damages resulted from Scalpel's work. And I think we're talking apples and oranges here with respect to strict liability and damages. Strict liability still requires approximate cause, meaning the proof that the physical damages were caused by the list of excavators, the owner. So with respect to the first issue about strict liability, an owner may be found strictly liable, but one of the contractors may not be, even though they're in that line, because they may not have, their excavation work, even when you read the statute, may have not proximately caused. That is different from cost, which the plaintiff and the judge in this case, in this decision, discussed. So she, in the first instance, we argue, was wrong with respect to the strict liability because at that juncture, which was the procedural posture of no real discovery, she's basing it on an unauthenticated letter where allegedly someone from Scalpel said there were settlements to their property. And if I may just have a few, another.
No, that was an email, right? A business record.
No, it was a letter that at the time of the prima facie was not authenticated. There was no depositions or anything. But if you,
is there any doubt that it's authentic?
I will say this.
Are you saying it's a fake?
No.
Okay,
Forgetting
so
the
let's
letter
assume that that's not an issue.
I will say this, with respect to the experts, this court, and I believe Judge Rodriguez was on that panel, had all 3 experts in front of them and made the determination that at the time, Scalpel's work has not been proven to be a proximate cause of the damage. And part of that reasoning goes to these renovations. And the renovations that were going on were by plaintiff were still taking place in and around the time the excavation began. So that there was always a fight between our property and their property about the damages. Nobody ever walked over and conceded that all this settlement was because. Secondarily,
Wait, then I'm confused. I thought that the renovations took place years before.
There were 2. There were 2, 2006 and 2014. And again, the procedural situation was we hadn't had real discovery on what was going on with 2014, which is on and around the time of the excavation. So the procedural posture, which is part of our appeal, that we needed more discovery at that time. Then when you look at the whole record, the plaintiff was allowed to add in a serve reply and a reply, all these depositions and things of that nature, which still doesn't affect the prior decision of this court that had all 3 of the same experts that are in this case and still made a determination that there was not proven that Scalpel's work was the proximate cause of the excavation. And that reconciles with the failure of the court to, reconciles with the issue with the breach of contract. And I say this because the breach, the license, that motion was really between them. But what I want to point out to meaning
When you say them, you mean Freeland and.
But what I want to point out is
Plaintiff.
there were obligations that the plaintiff owed. It's a limited license. And that's where it's reconciled. If you already have a decision where Scalpel may not have been the proximate cause, and they're supposed to be doing stuff part of the contract, they're supposed to be doing flashing.
But you have, in your case, you have your client admitting that the damage occurred, right? The only issue with respect to your client is whether that is attributable to your client's work or something else.
He said he saw settlements. And then at his deposition, right, but at his deposition, he said it wasn't Scalpel's work, it was the prior renovations.
Okay, but that's a different issue as to whether or not the defendants, under the statute, caused damage.
Understood, but there's also a prior decision of this court that found that Scalpel's work has yet to be determined to be the proximate cause, which would then relate to the strict liability.
Didn't your client make a statement which admitted that the prolonged duration of the dewatering process was the main cause of the settlement that was reported in plaintiff's building?
The settlement per se is not necessarily the cause of the damages they're claiming.
Well, it's certainly part of it.
The plaintiff, all we're saying is for purposes of summary judgment, the plaintiff has failed to prove that Scalpel's work was the proximate cause of their damages. That's the issue. Thank you.
Thank you. Okay, United.
Good afternoon, Your Honors. Thank you. Peter Reed for United. I couldn't disagree more with the statement that the possible negligence or fault of one contractor in the chain is to be answered by anyone who did any work in that chain. And that's exactly what my motion on behalf of United was. The lower court decision wrongfully granted DFA summary judgment against United Drilling and wrongfully denied my motion. Basically what happened is, in reading it,
Wait, so can I just quickly ask you, is it your position that the plaintiff has to show proximate cause as to every one of the defendants?
Absolutely. Absolutely. That's expressly stated in the case law that I'm reading on the statute, that they say if there is damage proximately caused, it's right in the decisions. So absolutely, that's the case. And, there's nothing in the statute that says that for sure. So absolutely, that's our position. Unfortunately, I think what happened in the lower court was that there possibly was some sort of the usual circumstance where all flows down to the last subcontractor who's the one to answer. I think there was maybe an assumption by that of the lower court. They completely mischaracterized the facts of this case and mischaracterized my client as the excavation contractor. Nothing could be further from the truth. Scalpel always was the excavation contractor responsible for the excavation work, the shoring, the underpinning, and all the dewatering. My client was hired by Scalpel for a limited, tangential scope of work 4 months before any damage occurred to piles on the south line of the property. It was not abutting the plaintiff's property line, but in any event, that scope of work was completed 4 months before any damage was noticed. We were never called back. No one ever implicated us in any of the thousands of pages of correspondence that went back and forth between these parties to call us back to the site or even suggest that what our work had anything to do with any problems that occurred next door. So the lower court, misunderstanding my role, my client's role, then continued just to lump my client in with the rest of the parties to the case. My client did not perform any excavation work at the time of the accident. They just did the drilling on the south line. They didn't do any dewatering. They weren't responsible for any of the protection work that goes along with that. That was all Scalpel.
Sir, how do you respond to your friend's statement? I think it was in response to a question I asked him, that you can deal with this at the trial. With respect to apportionment, you can put in all your evidence that you were not your work was not a proximate cause or whatever the appropriate causal standard is under this statute, and perhaps the jury will side with you and you'll be let out.
Well, that all might be true, but that's just not the law. I just disagree with that proposal, because I think the law clearly states a party that has been found to have whose work is a proximate cause of that damage is liable under this statute, and if not, you're out of the case. I don't have to wait for a trial to adjudicate comparative fault between our co-defendants. If I'm a separate defendant in this case, he is not the plaintiff, nor any of the co-defendants have made out their claims against me under this statute or in common law. So when I made my motion for summary judgment, it was supported by the full record with an expert opinion that said none of my work was a cause of any of the damage on the abutting property. None of the experts who submitted contradicted that conclusion at all. The closest anybody came to say was, I think, Scalpel's expert, who said, I cannot rule out the possibility that it could have been damage, that their work could have caused damage if their work wasn't done correctly. There was conjecture upon conjecture. There's no evidence anywhere in the record that my client performed its work in any faulty way whatsoever. So just in conclusion, yeah, the lower court ignored the proximate cause aspect of the cause of action against me, and I believe that by misapprehending my role at the site, and if they had understood my role at the site, the proximate cause issue entitles me to dismissal of the plaintiff's claims and the claims by both co-defendants, because no one has proven that any work I performed was a proximate cause of any damage whatsoever.
Okay, thank you. All right, let's hear rebuttal. Did you have a question? Did I cut you off? No. Okay.
Your Honors, I'd like to address the question that you asked previous counsel about if there's a strict liability, does that necessarily mean that there must have been a breach of the contract? In this particular case, with this particular contract and his language, the language, the answer is an unequivocal yes. For strict liability, they have to be performed excavation work, and my client's building had to have been damaged. My client's building was damaged. We know this. Everybody understands this. The judge found that at least some of the defendant's work caused that damage. If you look at the language...
So then my question to you is, do you agree that you have to show, under the statute, that you have to show proximate cause as to each of the defendants that you've sued?
I don't, but if that...
You don't?
I don't agree with that. If that is the premise,
So let's just start with United Drilling, because that's the one that I think I want to hear. What evidence have you submitted to show that they were a proximate cause of the damage to the building?
The evidence is that they were working at the excavation. I agree that the focus of the excavation work that caused the damage was Scalpel.
You're saying that that in and of itself is enough to show proximate cause, that they stood on the building at some point and did some work? That's enough to show
not just some
proximate
work. They did some work having to do with the excavation. They were the sub of Scalpel performing...
So you're saying that anybody who did any part of that excavation work, including like the people who cleaned up the debris, that's what you have to show?
No, not people who cleaned up the debris. That wouldn't be considered excavation work. What they did, you could have a semantic argument. They were part of the excavation work.
I'm asking you, what did they do? What is it that you think they did that caused damage?
I can't say that there's anything in the record that specifically says what United did, but I would like to focus on Scalpel, because what Scalpel did undoubtedly caused the damage because they admitted it. And I reject counsel's statement that that conclusion is based only on their letter, which is damning, by the way, but it's not only based on that. We had 2 experts that submitted affidavits, both of whom found within a reasonable degree of certainty that it was caused by excessive dewatering. That's what caused the settlement of my client's building. And when a building settles like that, that's when you find the cracks, the staircase out of alignment, the doors not closing, and the stability of the entire building being at risk.
Just a side issue before your time is up. Does our prior decision on the indemnity of Scalpel have any bearing on this analysis?
Not at all. First of all, obviously, it's not part of this record, but to address your question, it doesn't have anything to do with that. We're analyzing it under a separate analysis. I would like to address just one other thing because I didn't get a chance to do it.
I understand, but we've given this case probably the majority of today's calendar.
It's one sentence.
No.
Okay.
Oh, come on.
Thank you, Your Honor.
All right. Everybody gets 1 minute after this. You know, we could discuss this case all day. Go ahead.
I've got to say I'll waive my rebuttal unless the court has any specific questions for me or my...
No, thank you. Okay. Scalpel?
I just want to give you the cite to the case, just in case so you don't have to look
We
for
have
it.
the cite to
Okay,
our
I just wanted to make
case.
sure.
I will
Also,
say,
very quickly.
Even though it's not part of this record, it's a published decision, we can look at it.
I just
Yeah.
wanted to make your life easier. Just so we're clear, the plaintiff only moved under one statutory code violation, which was the 3309.4. And it specifically says, if the person who causes the excavation it's about the licensing, but we would say again, we agree with United, each individual, that's how the case law has read, has to be the proximate cause of the damage, of the actual physical. Forget the cost.
What is the strongest case law authority you have for that proposition? That there's a discrete causal inquiry as to each of the actors in the excavation work?
Actually, I think nobody has really the plaintiff didn't address it in reply. I don't think there's any case really on point. Most of the cases that we're discussing about strict liability are where buildings, especially the Seminole case, Yemen, where the buildings are literally being physically moved. Here, what we're talking about is a possible dewatering that made settlements. And then the settlements possibly caused all of this other damage within their building. At that time, they never left that building. There were no stop work violations, and they were doing their own renovations. And in our expert reports, there's intimations that their own slabs were already bad and already causing the issue. So the question becomes, what would have happened had the no excavation come? They still would have had the same damage to all their doors and stairs.
Okay, we understand your argument. Let's hear from United.
Thank you, Your Honor. Just to the point of the authority for the proposal that each defendant, a cause of action has to be made out against each defendant, and proximate cause is an element of that. I would point to this court's decisions in Moskowitz v. Birch and Cornett Properties versus L&M 2nd Avenue, where it stands for the proposition that case law interpreting New York City Building Code 3309 is clear that absent a showing of proximate cause between the work performed and the alleged damages, there is no liability under that section.
Well, that's sort of cast in the passive tone, though, right? That's
Yes.
saying a proximate cause between the work, whose work, and the damage.
That's right, Your Honor, which is why because the only cases I could find were Second Department cases, which affirmatively said that a defendant is entitled to summary judgment dismissal where there has been no showing of proximate cause. Those are the Second Department cases of 211-12 Northern Boulevard Corp. and 492 Kings Realty LLC. They're in the brief.
Okay, thank you very much. Thank you all. People versus Shawnee Jones. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Legal Aid Society, and I represent Ms. Shani Jones. Ms. Jones is a single mother and a survivor of severe violence. Despite intense trauma, she has proven herself caring, industrious, and resilient. An extended period of PRS will inhibit, not facilitate, her rehabilitation. Subjecting Ms. Jones to the maximum term of PRS serves no legitimate purpose of sentencing, and her sentence should be reduced in the interest of justice. So first, Ms. Jones's personal history merits a reduced sentence. Her experience of violence and trauma specifically counsels in favor of a sentence reduction. She was a victim of neglect. She left school at age 9. She became pregnant at 13, moved in with her boyfriend at the time, and she was 14 when she delivered her baby, her only child, and almost immediately her boyfriend began beating her. These beatings were severe, they were daily, and after she finally escaped these really brutal beatings after about 5 years, her entire teens, her ex-boyfriend began stalking and harassing her. She was also sexually harassed at her first job. She was hospitalized for a week with suicidal ideation, and she suffered other traumas, including the murder of her best friend and an attack at knife point.
I'm sorry to interrupt, but very unfortunate circumstances that are present here. Would you agree that the only way we get to consider those circumstances is to find a waiver invalid?
Yes.
The waiver invalid?
Yes, Your Honor, that's true. And the waiver here was invalid for several reasons. First of all, the oral colloquy was ambiguous and affirmatively misleading. The court stated that she would waive all claims except those as to constitutional errors. That's, of course, incorrect, as this court recognized in Delgado, which is cited on page 18 of our opening brief. In addition, the court said that the appeal waiver was separate and apart from this quote-unquote, this plea, which is the opposite of what the court should have said. It indicates that it's actually an automatic forfeiture as opposed to a negotiated one. And the written form did not cure this because it had its own defects, and also it was not clear that Ms. Jones had read it, let alone understood it. In addition to her experience of violence, Ms. Jones is dedicated to her family, as evidenced in the record. She cared for her ailing mother. She ensured that her daughter would be safe before she was sent to prison. She's never been convicted of a felony before. She's a hard worker. As of her arrest, she'd been employed for 8 months. She's studied hard for her GED and sat for it multiple times, although she's never actually succeeded in passing it, which, just to reiterate, in addition to the fact that she left school at 9, really places her at a severe disadvantage with respect to understanding the nature of the waiver.
Let me just ask you a question on one small point in the record. And there were points in the record that your recitation of the record and the people seem to differ. So I just want to see if I can understand this. It's your position that at one point a plea was offered to her that for 2 years, correct?
Yes, Your Honor.
And that she was granted an adjournment in order to get her affairs in order, including for the care of her young child. And then when it came back, the offer had increased to 6 months, by 6 months, to 2.5 years. Is that right?
Your Honor, I believe what happened is that there was an original offer of 2 years, and then by the time of the plea hearing, the offer on the table was 2.5 months, and that appears to have been negotiated in conjunction with the adjournment. And as you say, the
It wasn't because of the adjournment that she got, that the plea was changed. I mean, that the sentencing exposure changed, was it?
Well, it's difficult to say conclusively that it is because of the adjournment, but I believe it's pretty clear from the record that...
Was there another arrest during that, at that time, that she was arrested for another assault 3?
Your Honor, during that time, she was arrested for another assault 3, which is a misdemeanor.
Isn't that what caused the change in the offer? As well as the fact that the district attorney agreed to go down from the assault 1.
That may have been the reason for the change, Your Honor, but...
And it had nothing to do with the fact that it was adjourned, that her sentence was adjourned. It was the extra time of incarceration wasn't extracted because she was given an adjournment. It had to do with her commission of another crime and the fact that the DA agreed to come down another count.
Well, Your Honor,
degree.
Yes. First of all, I'll note that the other charges were dismissed, but I also wanted to emphasize that the focus here is the PRS portion of the sentence. This extra 6 months has to do with the prison portion. But Ms. Jones has served her prison time. It appears she did well in prison. She was released on her conditional release date. And now we're looking at PRS. And the fact of the matter is that the question is whether this will protect the public. And the research shows that an extended period of PRS will not protect the public. If anything, it will hinder
But then
rehabilitation.
that's an argument in favor of reducing everybody to under 2 years. You know, you would have to show that these unique circumstances, that she in particular is deserving of that. Otherwise, we just do it across the board. All right, let's hear from your adversary.
Thank you, Your Honors.
Okay, you can proceed.
May it please the court, my name is Amir Kedmati and I represent the respondent, the people of the state of New York. Good afternoon, Your Honors. Your Honors, I understand you have already read the briefs, but I just wanted to highlight a few issues here. First of all, the victim in this case, Ms. Atkinson, was a young lady in her late 20s. She was assaulted inside of an elevator in the apartment complex where she lived by this defendant.
Was the waiver of right to appeal here valid?
I'm so sorry, what was that again?
The waiver of right to appeal, was it valid?
Your Honor, the waiver of the right to appeal was valid. The defendant knowingly, intelligently, and voluntarily waived her right to appeal. The oral colloquy was sufficient. The trial judge clearly separated the defendant's trial rights from her appellate rights, and he even gave her a PK warning by using the phrase separate and apart from your trial rights, you're also agreeing to waive your...
But the trial court did misspeak when it said that, when it limited what could be reviewed to constitutional errors, correct?
Your Honor, pursuant to Thomas, as Your Honors know, we are supposed to look at the totality of the circumstances. The defense attorney is clear on the record that he stated he already spoke with his client about the waiver of the right to appeal. Then the judge gave her the warning about the...
What did the written waiver say about this? What did the written waiver say about this?
Your Honor, I was just going to add that the oral colloquy as well as the defense counsel's statements were further supplemented by the written waiver, which clearly indicated what are the surviving rights and what are the rights the defendant will be waiving by means of the waiver of her right to appeal. But...
Did the court establish that she read the written waiver?
Yes, Your Honor. The judge asked her...
Where do we see that at?
Your Honor, on page 9.
I see. Has your attorney discussed that with you? Yes. Has she signed that? Yes. Please read that and sign it. Ms. Jones has executed the form. That's all we have.
Yes, Your Honor. I read that as I'm sorry, what was your question? Whether the defendant understood the waiver?
Did the court sufficiently ask or determine whether she had read the waiver, the written waiver?
Your Honor, I believe the oral colloquy was sufficient to establish that he is consenting to the terms of the written waiver. Some of the cases that my adversary cites are cases in which the court did not make any reference whatsoever to the written waiver. Here, the court gave the defendant an opportunity to further review the waiver one more time with her defense attorney, despite the fact the defense counsel stated they had already gone over it. But, Your Honor, irrespectively of what this court decides as to the waiver of the right to appeal, I submit to the court that the defendant's sentence was not excessive. Your Honors, this was a brutal attack. The victim suffered a laceration to her face that resulted in 90 stitches. She's sentenced to a lifetime of disfigurement. This defendant was arrested and charged with assault in the first degree. In fact, 4 violent felonies. The people, in light of all the mitigating factors that my adversary states here before Your Honors, those factors are all before us. We had a very strong case. We believe we would have been able to prove her guilt at trial if the defendant would have not taken the plea offer. And the only reason we offered her an assault in the second degree, despite the strength of our case, were precisely because of the mitigating factors that my adversary enumerates in her brief. And I simply ask Your Honors, if you do think that some of those factors deem a secondary review perhaps, also please do take into account the other factors pursuant to Farrar, such as public safety and deterrence. Your Honors, this defendant has a history of violent criminal conduct that has been escalating over the course of the past few years. As Your Honor stated, Even after this matter had already commenced in the Bronx Supreme Court, she picked up another assault 3 out in Manhattan. But even prior to this case, she was charged with assault in the second degree out in Queens and ended up being convicted of assault in the third degree just about a year or two before this incident. And there's also, I don't want to take the court's time any further, there's also a history of youthful offender adjudications and violation of probation. But in sum, Your Honors, I just want to tell you, I want to submit to the court that post-release supervision is precisely intended and necessary for a dangerous defendant, like in the case before Your Honors.
Thank you.
Thank you.
All right. We'll have some rebuttal.
Your Honors, I'd just like to quickly mention that the waiver was not voluntary, not knowing and intelligent. Again, as Justice Rodriguez pointed out, there is reason to think Ms. Jones did not read the waiver. She likely did not understand it. There's reason to believe that she has limited literacy, including the fact that she left school at age 9 and has not been able to pass the GED.
There was some confusion. So at one point, it said she left at 9. Another point, I read that she left from the 10th grade.
Yes, Your Honor. There is one report saying that she left, or that at least she didn't complete 10th grade, but I believe...
How could you leave school at 9? I mean, I don't even think that that's you can't drop out at 9.
Right, but she does report that she ceased attending regularly at age 9, and that's consistent with the narrative that she then, was plain hooky, that she became pregnant quite young.
And no question, she had a tragic life.
Yes, certainly, Your Honor. And there's also, despite that, she has really shown that she is on the road to rehabilitation. She has not been convicted of any crime in the past several years, not since this crime. Even before pleading guilty, she'd entered into anger management classes. Again, there's reason to believe her conduct in prison was good based on her release on her conditional release date, the fact that she is earning good time credits under less is more. There's really, in this particular case, I appreciate Your Honor's point that, PRS can't be reduced across the board, but the equities in this particular case do favor reduction of PRS. Thank you.
She under less is more. She might get that anyway, right?
She might, Your Honor, but less is more presumes an appropriate and proportionate starting point, and we don't have that here with the maximum.
Okay, thank you.
Thank you, Your Honors.
The next case for argument is APR Energy Holdings versus Deloitte Tax.
Your Honors, may I introduce Appellant's Pro Hoc Vitae Counsel. Good afternoon. I'm Stuart Slotnick from the law firm of Buchanan, Ingersoll & Rooney. I introduce Chance Lyman, my colleague from Buchanan, Ingersoll & Rooney, member of the state of the Bar of Florida. I would note that the prior sponsor to the Pro Hoc Vitae application was my colleague Jacqueline Wayand, who is currently out on maternity leave. Baby girl.
Thank you, and we grant your application. You may proceed.
Thank you, Your Honors, and may it please the Court. Again, my name is Chance Lyman. I'm here on behalf of the appellants, the APR entities. First of all, thank you for allowing me to appear and present argument on this occasion. If I can stress one point before this Court, it's that this case, the strongest basis for reversal here is the application of the proper standard of review to APR's complaints. I want to address inquiry notice first. In the simplest terms, the trial court went on a fact-finding mission and made arguments that neither defendant raised. Foremost among those is that the trial court determined that APR was on inquiry notice for the purposes of accrual simply by the virtue of receiving the April report. The trial court ruled that this is the moment that APR was on notice that something was amiss. This is a critical point. The court made that determination based on its own finding that APR's alleged late payment of invoices was conclusive evidence of inquiry notice for the fraud, for the issue of fraud. Now, apart from being an improper sua sponte argument, that finding is just simply not supported by the amended complaint, which the trial court had to accept as true, nor is it supported by the law. our complaint was decided effectively in the light most favorable to the defendants here. Now, the amended complaint and its exhibits show that APR fully intended to pay these invoices. They show that there was an executive who approved payment, processes it through the accounting department. There's a delay caused by Deloitte themselves when they failed to fill out some forms. In any event, all this is to say that the inferences have to be construed in APR's favor, and when you do that, there's no inference that can be construed that APR was on conclusive notice of fraud at that point. On the law, I want to direct your honors to this court's CSAM case. That supports reversal here as well. The point is that conflicting interpretations of perceived events precludes dismissal, okay, even on undisputed facts, and that's because the issue goes to state of mind. Particularly,
What fraud are you talking about? What fraud?
this is
You put a malpractice claim, right? What's different about your fraud claim than the malpractice?
Absolutely, Your Honor. It's the intentional inducement into the
If you're saying to me, I said I wasn't, I told you, I induced you to enter into the contract by telling you that I was competent, that is exactly the same, and I could cite you 10 cases that say that's professional negligence. Right?
I understand Your Honor's point.
So tell me what I want to know is what's different than that claim that turns this from a straight, because frankly, obviously, the only shot you've got here, because you agreed to a 1-year statute of limitations, is to say that no, this isn't professional negligence, this is fraud, I'm entitled to a statutory extension, because otherwise you'd be out of the box. So I want you to specifically tell me what allegations of yours are different between the negligent misrepresentation or the intentional misrepresentation or just the malpractice and the fraud.
Absolutely. So it starts in 2011. We've got an email attached to this complaint that Deloitte Tax and Deloitte Spain are basically concocting a scheme together. And that's before the engagement letters, Your Honor. They're developing a way to sell APR on this eventually very elaborate structure, okay? So, and really what supports that is the Johnson case that we've cited. This talks about when
Again, what is the difference between saying that and saying they malpracticed by giving us bad advice? You can repackage it. I'm asking you what is the difference, because I don't see any difference.
It's the intentional conduct motivated by the desire to profit off of the excessive fee. That's what the Johnson case says. I mean, it talks about when a scheme is given where they have no...
Does this, quote, scheme get started with Andrew Martinez of APR approaching Deloitte Tax and inquiring about the possibilities of reducing taxes under the Uruguayan tax treaties? And was it APR that perhaps suggested looking into using a Spanish holding company structure to lower those taxes?
There is no dispute that there was APR reached out to Deloitte to investigate this possibility. That's sort of what you can see what's happening in 2011. But that's not when the scheme, that's not when APR is starting to get induced into the scheme. That's later when APR receives this targeted marketing. That happens in late 2012. And then you can see the APR employee executive forward that targeted marketing to the Deloitte entities and ask, isn't this something that you can use for me?
And yet your engagement letter includes a sentence which says, in this regard, client understands that the result of any tax advice is not binding on the IRS, other tax agency, or the courts, and should never be considered a representation, warranty, or guarantee that the IRS, other tax agency, or the courts will concur with our advice or opinions. So you start off with an agreement that you can't hold them to anything they're telling you in terms of holding them liable.
That is absolutely in the engagement agreement, Your Honor, but there are representations that are being made outside that engagement agreement, one of which is the comment from the Deloitte Tax gentleman saying, if we can manage the facts and the law, the structure has good potential.
Again, that goes to whether or not they malpracticed, right? You're saying they gave us bad advice. That is a malpractice claim. That's a straight, you can't repackage it as a fraud claim.
I would just stress the intent element. And when they knew they didn't have, this was an untested plan, this was the guinea pig theory, and they knew they didn't have that experience, which, thank you, Your Honors.
Okay, Deloitte Tax.
Put my glasses on without steaming. Good afternoon, and thank you very much. And I do sympathize that you're ending your day with a tax matter, but it is elegant in its simplicity in this case. And your questions of my opponent really made my points for me, so I'll be very brief. On this sua sponte point, you know, that was made very vigorously in the reply brief, so to get ready for the argument, I went back and read the transcripts of our oral arguments on motions to the first motion to dismiss and the second motion to dismiss. And I commend those to you because they were long and detailed, and the court gave us a lot of time. And on page 21 and page 26, lead counsel for APR explained, and she's who gave the judge this idea, that they didn't pay Deloitte Spain because they thought they had been given bad service. So APR raised this issue at the first oral argument. It went right over my head, so when the judge mentioned at the next hearing, I thought, well, that's interesting. The other thing I will say is that when we argued this, briefed this, and argued it the second time around, we put before the court lots of evidence from the exhibits attached to the complaint that demonstrate that APR was on inquiry notice. Now, they don't have to conclusively decide in order for the statute of limitations to start running. They just have to know that they should be looking into it.
Wait. Are you conceding that they pled a good fraud claim?
No, I am not conceding that, and I agree that the fraud claims, all of the claims
Then
are
why are we
duplicative or
talking
being
about inquiry notice? That only gets there, you only get to that point if you're saying it's a good claim.
I guess I'm troubled by the allegation that the court was sua sponte when I read the transcript, so I felt I should say it. But it's our firm position that this is all a malpractice claim. All the other claims are duplicative and should have been dismissed. And because there's a one-year statute and the services that Deloitte Tax provided ended in 2014, they didn't file suit until May of 2019. They're out of luck. Their response—
Does that also apply to the general business law claim, the one-year statute of limitations?
You know, I haven't found any case that finds that to be duplicative and dismissed. So we argued that this is not a case that statute
Just on substantive, I mean, you know, it doesn't seem consumer-oriented.
No, I mean—
But are you saying that you can't shorten the statute of limitations for GBL 349 by contract?
I think you can. It would be 1 year from, and when did it accrue? But I just don't think that statute applies here because of this was a corporate restructuring and it was clearly formed through an iterative process. It's unique. But just to get back to this—
The question is does, under the engagement letter, 1 year statute of limitations that was agreed to, which seems to apply to all claims, would that cover the GBL claim as well?
Yes. I was saying I wasn't sure if there is case law to say that you could just dismiss the GBL claim as duplicative of the malpractice. That I'm not sure about. I couldn't find a case. It's kind of an interesting question. But I don't think, even if you get to that, it just doesn't state a claim. But on inquiry notice, it is beyond dispute that there is no allegation that Deloitte Tax provided services after 2014.
Is our prior decision in Johnson versus Proskauer distinguishable?
Yes, because Proskauer, it's a great question. In that case, Proskauer was alleged to not only engage in tax malpractice, but also fail to disclose a conflict of interest. I believe that's a tax shelter case where they had an arrangement where they were representing taxpayers as well as the builder of the shelter. They didn't disclose that, and so that was what took it out of the rule that we're relying on. Thank you, Your Honors.
Thank you. Well, let's hear from Deloitte Spain.
Good afternoon, Your Honor, Your Honors. George Salter from Hogan Levels on behalf of Deloitte Spain. I was going to focus my presentation on the personal jurisdiction point, because if there's no personal jurisdiction, then there's no really need to discuss the merits. With that said, let me just comment on one aspect of the merits allegations. In the reply brief, no less than 8 times, and even in opening remarks today from APR's counsel, there is an allegation that APR alleges that Deloitte Spain has been an integral part of the fraudulent scheme since its inception in 2011, a fact they say that Deloitte Spain entirely ignores. And they base that allegation on an email exchange, which is Exhibit 4 to the amended complaint, record number 208, which is an email involving Deloitte Tax and Luis Ponce, who in the email says is from Quito, and it reflects that he's from Quito, Ecuador. For some reason, there is an allegation that that is a communication going back to 2011, that Deloitte Spain was involved in the inception of the scheme. That's just not the case. Luis Ponce is not from Deloitte Spain. You can see that from all the other emails in the record involving Deloitte Spain. It says the domain name of the email address is @deloitte.es, and the email name says Madrid.
Let me ask you, I mean, regardless of whether or not you're an affiliate, why doesn't the section of the engagement letter that says that no affiliated or related entity of Deloitte Tax shall have any liability hereunder to the tax client, why doesn't that absolve you?
Yes, Your Honor, it does. If you were going to look at the merits, if you get past the personal jurisdiction, that would also absolve Deloitte.
Well, I mean, isn't that, I mean, everyone's agreeing that the contract was made and that everyone agreed to all its terms. There's no doubt the contract is enforced, right? So regardless of whether or not there's jurisdiction, personal jurisdiction over you after Daimler, which is always a complicated issue, isn't it your argument that no matter what, I'm still covered by the engagement letter?
If there is personal jurisdiction and the agreement is in place, then yes, that Deloitte Spain would get the benefit of all the terms of the agreement, including the shortened
the statute of limitations.
Yeah, and the limitation on damages.
Would that hold true if there was a cognizable claim for fraud?
I think it would still hold true because the only way that you'd have personal jurisdiction is through that engagement letter, arguably. I could go on to say why we don't think that's the case, but my time's up. If you don't have any other questions, I'll sit down.
No, I think we're good. Thank you.
Thank you.
All right, let's hear again from the plaintiff, APR, on rebuttal.
Thank you, Your Honors. Yes, I understand that Johnson is distinguishable for the conflict of interest issue, but I don't think that that's dispositive here. I think this claim is very, very much like the Johnson claim. This court said when you are representing that something will be effective, when you have no genuine basis to believe that, that can be a cause of action for fraud. And I think that's what we've pled here. We've used that language in our amended complaint. I do want to point out that I think obviously, as we just heard, Deloitte Spain has never argued that there's a limitations provision in the engagement agreements that says that they're not subject to liability. So again, that's just not something that's before this court, I don't believe. The personal jurisdiction inquiry should be resolved by the forum clause in the 2012 and 2013 agreements. The closely related...
What about the statute of limitations? If you have personal jurisdiction, do the statute of limitations shortening in the agreements and the engagement letters apply to Deloitte Spain?
I would concede that, but I would say that, and I think that Your Honor may be referring to this court's Aaron decision, that decision doesn't say that a contractual statute of limitations provision precludes all forms of exceptions to a statute of limitations argument. In fact, the limitations provision here uses the word accrual, so we know that it does not it doesn't avoid delayed discovery because that's a rule that defines when accrual happens. Equitable estoppel is a power of the court. It's not a tolling doctrine. This court in Aaron, did not hold that the contractual limitations provision precludes all forms of exceptions to the statute of limitations. I would also argue that the continuous representation holding in Aaron is actually connected not just to the contractual limitations provision, it's connected to the fact that the Deloitte entities and the Deloitte entity in that case actually did stay within the temporal scope of the letter, and that is a huge distinguishing fact in this case. I'll conclude with that, and I would ask this court reverse the orders. Thank you very much.
Right, thank you all. Thank you very much for your argument. People versus Gustavo Rodriguez. You may proceed.
May it please the court, Shana Watrous on behalf of Gustavo Rodriguez. I would like to address two issues today. First, the failure to charge the lesser included offense, and second, the excessive sentence, where this was 19-year-old Gustavo's first offense. He was not the initial aggressor, and he's had an outstanding focus on education, both before and since his sentence. So when it comes to the lesser included offense, Gustavo himself testified at trial that he did not mean to stab the decedent, but he was being choked and trying to push the decedent off. So viewing the evidence as the court needed to in the light most favorable to the defense, the jury could have found that his actions were reckless, but that the stabbing was not intentional. The court could have credited his testimony and found him guilty only of second-degree manslaughter. And the court's failure to present that option to the jury requires reversal.
Wasn't the trial evidence strongly suggestive or demonstrated that there was a stabbing motion as opposed to some sort of slashing motion that would suggest that the stab, for whatever reason it was affected, was an intentional act?
Well, he does say that he was, lunging, trying to push him off of him, trying to get him off, trying to break his grip. So certainly there was an intentional movement to push at him. He had to push quite hard. This was a man on drugs who was twice his size. But, it is conceivable. There was a reasonable view of the evidence, again, in the light most favorable to the defense, that, he was telling the truth. The jury should have been allowed to assess his credibility and believe his story.
There's also evidence that the stab wounds were deep, wasn't there? And doesn't that also counter your claim that there should have been a manslaughter 2 charge because it connotes intentional rather than reckless?
I would just say the same thing again, that he was intentionally trying to push him. He was pushing hard. That might account for, the depth of the wounds. But again, the jury should have been able to decide this as a fact. The jury would have known the depth of the wounds, but they should have been able to have this option in front of them. And it was error for the court not to charge that.
You're phrasing it as intentionally pushed, but isn't it more that he intentionally lunged at the victim while holding a knife?
He lunged at the decedent, yeah, but he says
that's an intentional act, correct?
Correct. He was intentionally trying to push him off. He says, I was trying to get him off. Repeatedly in the record, he testifies that he was not trying to stab him. He did not intend to stab him. This is page 602 and 603 of the transcript. Is it your testimony as you sit here now that you didn't know whether you ended up stabbing him? This was a man who was wearing a coat. He was trying to push him off, and the jury really should have been able to consider that.
Counsel, the thrust of the defendant's defense is that I was justified, right? I didn't set this in motion. He was the initial aggressor. So the focus wasn't so much as my conduct was reckless. It was I was justified in what I did. Isn't that the thrust of the defense?
He does have a justification defense, but that doesn't preclude The fact that he also said that he was justified in trying to push him off. But the Court of Appeals found in People versus Huntley, that's 59 New York 2nd 868, that second-degree manslaughter the charge is proper to the jury when there's also a justification defense. So it doesn't matter that he was making that apparently inconsistent defense. It's still, as long as he provided evidence, as long as there was some evidence that that would have been a reasonable view that he was only reckless in his actions, the jury needed to be presented with that charge.
So you're saying, I mean, he admitted that he intentionally lunged at the victim with the knife in his hands. And you're saying that that is evidence of recklessness?
Yes, it was a risk that he...
pushing, he came up and intentionally lunged. He wasn't pushing him off of him. He admitted that he came up and pushed the knife, lunged at the victim with the knife. And you're saying that that could be found reckless?
There's maybe a semantic difference in what he understood lunging to mean, but he also says he was trying to push him off, trying to break his grip.
I don't see any cases that would support that. I think all the cases that I read went the other way. That's my problem.
There are several cases.
There are cases where it says, I intentionally lunged at the victim with a knife, and that would support that I didn't intend to cause serious injury?
There were cases that we cited, yes, in our brief, that when there's a struggle, if there's a stabbing during that struggle, especially in a case like this where he says he didn't mean to stab him, again, you might not believe it, but it really was up to the jury to decide this question of fact.
Counsel, isn't it the case that if the jury had credited the defendant's testimony that he was justified in stabbing Olivares or that he did not intend to cause serious injury, that would have entitled him to a straight acquittal?
That's true, Your Honor, but when it's a question of mens rea, when it's a question of recklessness versus an intentional stabbing, that is most important. This court has said it's most important for the jury to have that option to review that. I do want to turn to his excessive sentence because this was a young man who was 19 years old. He had no criminal record when he was violently attacked by the decedent in this case. And I can continue that in rebuttal.
What do you think is an appropriate sentence? This seems like a fairly lenient sentence where somebody's been killed.
Right.
16 years.
So the minimum here was 5 years. It's a 5 to 25-year range. He got more than 3 times the minimum that he could have gotten for a death. And given the fact that he has been so committed to education, he has been given a full scholarship to Manhattan College upon his release.
And that's commendable. I think that is wonderful that he's done that. But I think when we look at excessive sentence, we can't really look at after occurring events.
Well, Your Honor can look and can review what the trial court had before it at sentence, and this was before the trial court at sentence.
Oh, that he was going to Manhattan College?
Yes, that he had been granted a full scholarship at Manhattan College, that he had been commended by, I can continue on my rebuttal.
No, as long as I agree with you on the principle that, and it seems like the court considered that. Yeah. Okay, thank you. Let's hear from the people.
Good afternoon, Your Honors.
Counsel, can you address the excessive sentence argument first, please?
Absolutely, and I think, Your Honor, Justice Gish was absolutely right. Like, it is commendable that the defendant has an educational background, and we didn't, in this brief, dispute any of that. The issue really comes down to the 16 years is a range of 5 to 25, and it was 16 years after he viciously stabbed. There was 2 stab wounds, 5 inches and 3 inches. There was a loss of life here. He abandoned Miss Barrera at the scene. He abandoned this person at the scene. He clearly committed perjury on the stand. And the jury found that. And given all these things, the judge then factored that against what are these very good things about this particular defendant. And he carefully crafted a 16-year sentence.
Counsel, when you say that the jury clearly found that, and you were referring to perjury, you're not I assume that what you meant is that the jury did not credit the defendant's testimony.
Correct. They
There is
rejected.
no finding of perjury here.
Absolutely. They rejected his testimony.
Correct. And now,
But I would just
something's-
like, I'm sorry.
Go ahead.
No, I was just going to add that some of the things the defendant said, and I think the court said this at sentencing, were just absolutely hard to credit. Meaning that, like, he was, when we were all talking about the stabbing before, it was 6 inches away of a 350-pound man, and he said he didn't even know if he stabbed him. So I think the court looked at that as an aggravating factor.
In the defendant's favor, you have, however, he was 19 years old when this happened. He had no prior criminal history. He was employed. He's expressed remorse. He was apologetic. The victim was, what was it, 140 pounds heavier than he was. It was the victim here that initiated this incident, right? Doesn't that weigh in favor of some mitigation for the defendant?
Well, he got that mitigation from the trial court because all these factors were before the trial court. And as I was saying, and you could look at the sentencing minutes, the trial court did talk about that he had to find a sentence that was appropriate here, given everything that you've said, Your Honor, which is absolutely true, and given all of the factors that I said before, which were, you know, the actual stabbing, his callous conduct after the stabbing. He left Miss Barrera there at the scene. So all of those, I thought you were...
No, I'm sorry.
No, I'm sorry. I thought you were going to speak again. I apologize. So when the court saw that in its totality, that's when it came to the determination that 16 years, which is essentially a middle of the road sentence here, because you have 5 to 25, and 50, you know, it's a 20-year range, and he got 11 years higher than the than the minimum. So it's a middle of the range sentence. So
What did the trial assistant ask for?
The trial assistant asked for 25 years, Your Honor. And the court, you know, obviously weighed that and didn't think it was appropriate and gave a sentence that it gave here. And the people understand, as I said, you know, that this was a situation in which this defendant has a lot of good things. But at the end of the day, what I want to focus on, the fourth factor that I haven't gotten to yet, was the family. I mean, there's no doubt that this victim had issues, but he had a daughter who lost her father. He had a mother who talked about the traumatic experience. The father who was there that night, who dropped him off, they worked together. He had talked about that. So this was a loss of life. This was not simply just some sort of crime where, you know, someone can get better. We have permanent loss here. And I think that's what the court was getting at when it carefully crafted the 16-year sentence. Does the court have any questions for me on the prior about the lesser included intent?
No.
If not, and if no other questions about the sentence, I'll just ask that the court please request that the court confirm the conviction. Thank you very much.
Thank you. And we're going to hear some rebuttal.
So I know the respondent talks about his callous behavior afterward, and certainly, you know, his behavior was inappropriate. This was a youthful, immature response. He was a teenager. He panicked as a teenager would. Just because of his youth, and his response to that doesn't justify a sentence so far above the minimum. You know, he expressed deep remorse to the family. He acknowledged that the decedent's nephews wouldn't be able to spend time with him anymore. And that was very personal for him, because my client also has a family that loves him very much. He has nephews also. He has sisters who are watching this argument as we speak. And you know, he's not someone who needs to be incarcerated for 16 years of his still young life. He has so much...
Did you say what the sentence should be reduced to?
We would just ask for it to be something closer to the minimum. I understand if that's not acceptable to this court, but something closer. You know, he has big dreams. He's excited to go to Manhattan College. And he's someone who all the corrections officers at Rikers Island, this also is in the record, were giving compliments to the programs that he was a part of because he reflected so well on them. He's a truly extraordinary young man who, you will make something of his life. It's not in the community's penological interest to incarcerate him for this long, and we would just ask that there be a sentence reduction. Thank you.
Thank you. Thank you. Thank you both, counselors. And finally, the last case that's on the calendar for argument is Curion versus Schreiber. First, let me thank you for waiting so long while we got through our pretty formidable calendar today, and we appreciate your patience.
Thank you, Your Honors. Good afternoon. May it please the Court. Eliad Shapiro from Moses and Singer LLP, representing the appellants Joel Schreiber and Waterbridge Capital LLC. We finally made it. This is a usury case, one in which the plaintiff admits on the face of the verified complaint that he charged usurious.
The Supreme Court dismissed the claim for constructive trust on the ground that the plaintiff did not allege the type of fiduciary of a confidential relationship required for the establishment of a constructive trust.
Yes, Your Honor.
So in effect, Supreme Court found that there wasn't a fiduciary relationship here?
I beg your pardon? I didn't hear the question.
Does that mean that Supreme Court found there wasn't a fiduciary relationship here?
Yes, Your Honor, that's exactly right. The Supreme Court actually went so
Plaintiff
far.
hasn't appealed from that finding, has he?
That is correct. Plaintiff has not appealed from that finding. The court went further and held that there's actually an arm's length relationship here between the plaintiff and the defendant.
So as a
Joel
matter
Schreiber.
of law, as the case now stands, there isn't a fiduciary relationship between plaintiff and the defendant, the individuals at least.
That's correct, Your Honor. Neither fiduciary nor confidential, no heightened relationship whatsoever. We're dealing merely with an arm's length relationship between borrower and lender, in which the lender charged usurious interest rates from a minimum of 60% per annum to as high as 389-ish per annum percent.
Can the plaintiff say that we should disregard the usurious nature of the loans because of the special relationship between us?
No, Your Honor. There's no special relationship alleged in the complaint. And in fact, the verified complaint not only contains a paucity of allegations establishing that, I mean, there's simply, whatever allegations it does contain forecloses the possibility that a special relationship
In fact, there's
exists.
an unappealed finding in this case that there is no such relationship.
That is correct, Your Honor. That is an unappealed finding that there is no there is no fiduciary or heightened relationship that is the bedrock of the special relationship.
Would that conclusion change at all if there was a claim made, and we understand we're on pleadings now, if there was a claim made that the terms of the loan agreement were all dictated by your client? Does that make a difference?
Your Honor, that would only make a difference if the other elements of a special relationship were present, such as superior knowledge or expertise on the part of the borrower, or representation of the legality of the loans, or reliance that's justifiable. But what's notable about the verified, none of that is in the complaint, not once. But
as we're talking about this, it dawned on me, why would we impose a pleading obligation on the plaintiff in that regard to plead a potential exception to an affirmative defense? You raise usury, and now, and only because usury is raised as an affirmative defense, does the potential of this exception to the usury defense manifest itself?
Well, Your Honor, the plaintiff...
So I understand that we do have to look at the complaint and what's in there, but as far as imposing some sort of formal pleading requirement on a relationship that would overcome the usury defense, I know that may be a bridge too far for me. But we also had that affidavit that Mr. Curion put in opposition to the motion.
That's right.
Of course, he now is informed of what your defense is.
That's right, Your Honor. So I'd like to address 2 points to that. First, none of the decisional law really imposes, it's not about imposing a pleading requirement. The facts still have to be in the verified complaint. But as Your Honor points out, in the affidavit, where the usury, after our usury argument was made, plaintiff had an opportunity in the affidavit to assert whatever facts he wanted. No facts were asserted. The only thing that's asserted in the affidavit is the conclusory claim that Mr. Schreiber, quote unquote, proposed the terms. But if you look at the verified complaint, it contradicts. The verified complaint contradicts that claim on pages, I think it's 37 and 38 of the complaint, for example. In paragraphs 120 and 121 of the verified complaint, we see plaintiff alleging that he proposed terms to Schreiber, which Schreiber agreed to, not the other way around.
But even if it were true, the fact that your client may have proposed or even dictated the terms of the loan agreements does not in itself create the special relationship that would otherwise be an affirmative defense to usury, does it?
That's correct, Your Honor. It does not give rise to that argument, and as we've already established, the lower court has already held, now as a matter of law, there is only an arm's length relationship. Without a heightened relationship, you simply don't have the special relationship.
On its face, the terms of these loans, as alleged, are usurious.
Correct, Your
It's not like you've got to do some computation to figure it out. I mean, it's clearly the rates are not permissible rates.
You're right, Your Honor. That is 100% correct. The allegations of the complaint establish the usury on their face.
Okay,
Thank you.
thank you. Let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court, I'm Jason Stewart on behalf of Plaintiff Vikram Kurian. At the outset, I'd like to address 3 important points here. First, as Your Honors noted, this is a pre-answer motion to dismiss. We're asking the Court to make legal determinations here bereft of a complete record and without any discovery. Significantly, as Your Honors...
Since it seems that you need this fiduciary relationship, why didn't you appeal from Supreme Court's order insofar as it found that there is no fiduciary relationship? You're an aggrieved party as to that.
Well, Your Honor, reading the decision, we read that the Court found that it was premature to make a determination with respect to the question of usury. And so I believe that the decision
Court didn't say it was premature to make a determination that there's no fiduciary relationship.
Well, but there is some discussion as to whether or not a special relationship existed by and between, and the allegations within the complaint said...
What is the difference between a special relationship and a fiduciary relationship?
Well, I believe that a fiduciary relationship is defined in the court and in the case law as something specific, where a special relationship is a little more vague. There's a little less of a certain determination there. Specifically, I think a special relationship here can be met by the friendship that's alleged in the pleadings here. That there's
I think friendship alone can otherwise be in a defense to a usurious loan?
No, Your Honor, I do not think that friendship alone, but looking at the totality of the circumstances and really...
Okay, so now I'm going to ask you, right, and giving your client every favorable inference of the pleadings as amplified by his affidavit, explaining the facts, what facts do you base this special relationship on? What are the best facts you have?
Well, Your Honor, you had a relationship that goes back several years prior to the loan ever taking place. This Mr. Kurian was a frequent visitor, and this is set forth in the complaint. He was a frequent visitor to the offices of Joel Schreiber. They had continuous and ongoing relationships and dealings. They had proposed business dealings that did not materialize before the first loan ever came into place. Multiple representations were made by Mr. Schreiber to Kurian about his ongoing business affairs.
Your client's a very sophisticated person, is he not? I mean, didn't he specialize in capital markets?
And those arguments are espoused by my adversary that Mr. Kurian is a sophisticated...
Had a doctorate in finance?
He had not and is not sophisticated in the area of lending money. He has worked for major banks and he is a graduate of some high esteemed colleges, but his specialty is not in day-to-day business transactions. And he was induced and he relied on representations that were made by the defendant. When the defendant came to him looking for money, he said, this is how I do business. This is how let's do a handshake deal. We're friends. You'll be fine. This is how we will be taken care of. There is no harm here for you.
Now that sounds more like it. But where is that in the complaint or in the affidavit that your client submitted in opposition to the motion to dismiss.
Well, and to your earlier point, this wasn't something that was set forth in the pleadings because affirmative defense, because usury is an affirmative defense, and it needs to be proven. And there's ample case law out there that usury will not be implied. It will not be inferred. It needs to
Well,
be
I think
proven.
as Judge Friedman pointed out a few moments ago, from the face of these transactions, they were usurious.
Well, but they were not.
Still, if you annualize the interest rate.
They weren't contemplated as being annualized interest rates. This was a short-term
I
lending
mean, you're
transaction.
asking us here to accept that someone who's got a doctorate in finance doesn't know anything about the concept of usury.
You're absolutely right, Your Honor. That is an inference that I'm asking you to accept here. And the fact of the matter is the case.
Criminal
can I
usury.
just ask
He has
you
no
one-
idea about criminal usury.
I mean, I've heard what you've said, but it's all like, we were good buddies, we hung out, we talked business. You're saying that that creates essentially a fiduciary relationship?
I'm saying under the facts of this case here, where
Which
there was,
are,
there
as
were-
you just laid them out, we were good buddies, we hung out, I came to his office, we talked business all the time. That creates a fiduciary or special, I mean, you call it special, but really what you're saying is a fiduciary relationship?
Your Honor, maybe perhaps I could point to, there is another component that we discuss in our briefs, in O'Donovan versus Galinsky case that speaks about, there's no evidence that the defendant did not set the rate that they knew to be usurious for the purposes of avoiding repayment of the loan. And that's one of the prongs under which we submit under our affidavit that Mr. Schreiber set the terms of these loans. And I will point to the record, which is contained a lot of instances here. Mr. Schreiber is a serial defaulter. This is not the first time he has gone through this. And because of that, I think you can look to the greater circumstances here and not presume usury at this early stage. I thank you, Your Honors.
Okay, thank you. Rebuttal?
I'll be brief. The only allegations of friendship, quote unquote, that are anywhere in the pleadings or in the affidavit are the conclusory claim that Mr. Kurian considered Schreiber a friend. That's a quote. That's it. This court in Polis.
But let me ask you this, so what counsel just said to me is very interesting, was basically that if he had paid the loans off on the time, they wouldn't have been usurious, right? You have to annualize them to find them to be usurious, and none of them were annualized loans. They were all short-term loans, correct?
That is what's alleged.
Right. So prior to discovery, should we find, as a matter of law, that they were usurious if they were paid back within the time that the loans alleged, they wouldn't be usurious?
Well, Your Honor, the law in the First Department is consistent that it doesn't matter whether the term was meant to be for a year, 2 years, 2 days, 2 months, and that's the Bakash v. Wilson case, for example, where where the loan's term is for under a year, where even if it's intended to be under a year, you take that interest rate, you multiply it out so that you annualize it, and that's the interest rate that you use to calculate usury. And there's no doubt, based on the interest rates that are alleged, that that's what's happening here, usurious interest rates on a per annum basis.
So your your adversary claims that it might be that your client, did this deliberately in order to avoid paying back money that he otherwise would have owed. Is that a factor to take into account in terms of cases involving criminal usury?
No, Your Honor, and in fact, there's no such allegation in the verified complaint. There's no such allegation in the affidavit. And in fact, what the verified complaint does allege is that the verified complaint alleges that my client repaid about 60-some-odd% of the loans, $462,000 of usurious principal. The complaint alleges my client repaid out of about $750,000 in usurious principal. Does that sound like someone who's trying to get away with stealing money? He was trying to repay before plaintiff brought this action to enforce his usurious loans.
Well, I can't look into his mind as to why he did that or why the plaintiff did what he did, quite frankly. So I make no judgment about what these parties intended one way or the other.
Fair enough, Your Honor. But what is alleged in the complaint is the repayment of 2/3 of the loans. Okay. Thank you.
Thank you. Thank you both.
Take care. Thank you.
Have a good evening. Thank you for your patience.
Thanks.